Apologies we've received. Apologies from Stuart Dixon, Chris Hazard as well. And it's my understanding Edwin Pitch is going to be late. And I know that Sammy Douglas was at a Standards and Privileges Committee and will bring to join us very shortly. Any other apologies from anyone? Okay, shortly. Okay, move on then to agenda item 2 is the draft minutes of the meeting held on the 14th of January. If I can just ask you to glance your eye over the minutes, pages 6 to 13. If you're packed and if you're happy enough with that, I'll sign it.
Yes, sure.
Okay, yep. Okay. Matters arising. Forward work programme. Arrangements have been made for the Minister to attend the meeting on the 28th of January to discuss the 15-16 budget. The issue of the reconstitution of the Policing Board will be on the agenda for that meeting as well, as was agreed at the committee last week. And an updated forward work programme, which includes details for February, has been circulated at pages 4 to 12 of your tabled papers today. Okay. Second issue is correspondence regarding Ballymena Railway Street Addiction Centre. Patsy McLogan's provided the letter he received from a community pharmacist regarding withdrawal of funding from the department for the addiction centre and the need to maintain the service. Letters at pages 34 and 35 of the tabled packs. I know that Paul's going to visit tomorrow. I was hoping to, but I'll have to rearrange that and go to a future date.
Chair, just to speak on this, I think this proves that whilst I know that the committee here realises the importance of this service, and whilst it's based in Ballymena, it doesn't just serve Ballymena or even North Antrim, and it is much wider afield than that. And when this first was commenced umpteen years ago, this was a flagship project which has proven to be the way that issues should be dealt with, and has actually now been rolled out. The model has been rolled out in various other jurisdictions. So it just seems an absolute shame that we are potentially going to lose this service, which would make things a lot worse. And this letter just goes the whole way to prove that it has a wide sphere of influence throughout the province. Thank you.
Okay, members will recall 10th of December the department was still considering options for funding the project, and last week we requested an update from the department, the current position regarding funding for the centre both in year and for the 15-16 year. So we expect a response from the Minister before he attends the meeting, so that might be useful for the... Yeah, Raymond? Yeah.
The extra money this week should hopefully provide a bit of scope for it to be...
I think the money, the extra money is for policing, isn't it?
Yes.
So
For policing, is it just for
I
policing?
think it's specifically
Okay.
for policing stuff,
Okay.
but I think it's still worth exploring.
Oh,
it,
no, absolutely,
if
absolutely.
there's an extra. If we move on then to agenda item 4, if I refer members pages 16 to 42 of the meeting folder, we're getting representatives from the Health and Social Care Board to give evidence on the proposed amendment by the Attorney General to the Justice Bill. The papers, as I said, 16 to 42. A summary of the written evidence received by the committee in relation to the Attorney General's proposal is included in the bill folder and is also at pages 14 to 29 of the tabled papers. So if we ask the...
Can I just declare an interest that one of the witnesses is my brother?
I'll hold that against them before. Bit like Tesco.
He can pick his friends but not his relations.
Okay, can I just welcome Noel McAndrew, Director of Social Care and Children, Alfie McGuinness, Director of Legal Services, and Alan Keane, Governance Manager of the Health and Social Care Board. You'll be aware that the meeting's being hand-sorted and will be on the committee website in due course. So whenever you're ready, if you want to brief us on your views on this, and we'll open up then to members for questioning.
Okay, thank you, Chair. Now, I'm going to make a short presentation, just drawing the committee's attention to some of the issues we've raised in our response, and can I at the outset say that the Health and Social Care Board welcomes the opportunity to speak to this committee on this important matter. At the outset, I just want to reference the fact that in recent years, I'd like to commend the Committee for Justice and the Department of Justice for taking forward a number of initiatives that have directly benefited vulnerable children and adults in contact with the criminal justice system, many of whom are known to Health and Social Services. The Board has worked closely with the Department of Justice to deliver these and other improvements, which illustrates the value of collaborative working between criminal justice and health and social care systems from the highest level right to frontline services. In respect of the proposals being considered by the committee today, I would like to make the following points. Some of the proposals we would support unanimously. Many of them have the potential to be of significant benefit to vulnerable witnesses and victims of crime. And I'd like to make specific reference to those proposals for sharing victim and witness information under Part 4 to provide a more effective mechanism through which victims can automatically be provided with timely information about the services available to them. And again, the proposal contained in Part 5 in relation to the exchange of information. This is a small but important additional safeguard for vulnerable groups, children and adults, and should assist in ensuring that appropriate persons are enabled to work with such groups of individuals. However, there is a proposal, as you know from our submission, that the Health and Social Care Board has expressed some concerns about. I think we've set that out well in our response, but I'd like to just draw the committee's attention to a couple of issues that we have articulated in that response. Firstly, there's a robust argument that the current legislation provides a wide degree of discretion and a low threshold for action by the Attorney-General, where a decision by the coroner has been made not to hold an inquest, or an inquest had been held but was deficient, or fresh evidence had become available. In our view, the Attorney-General is already able to request all relevant documentation obtained by the coroner during his or her investigations into the deaths and could review this documentation. So in summary, we would contend that the present system is sufficiently robust to ensure that the interests of justice are properly served, and there is therefore no need for the proposed amendment. The Attorney-General's correspondence to the committee dated the 5th of March makes specific reference to securing access to documents such as serious adverse incident reports. This amendment would allow the Attorney-General to require any person who's provided health or social care to a deceased person to produce any document or give any other information which, in the opinion of the Attorney-General, may be relevant to the question of whether a direction to hold an inquest should be given by the Attorney-General. It is our contention that the relevant documentation will already have been provided to the coroner and will have been used by him or her to inform both the decision to hold or not hold an inquest. And again, we would respectfully suggest that this amendment is unnecessary. As I've mentioned, the correspondence makes reference to some difficulty in accessing serious adverse incident reports in the past, which he considers would assist him in determining whether a direction to hold an inquest should be made. And this appears to us to reflect a common misunderstanding of the purpose of serious and adverse incident analysis and reporting. The serious adverse incident process is primarily a service improvement process which seeks to identify and learn lessons for practice and organisations. It should not be seen as a vehicle for apportioning blame or determining culpability. That is a matter for other processes to determine as appropriate. The success of serious adverse incident reporting and investigation depends on the preparedness of staff to engage in the process in an open and transparent manner. This openness in reporting is positively encouraged in return for an assurance about the nature of any such report and how it will be used. As has already been noted, I've already made reference to the fact that this information is already made available to the coroner, if necessary, through the High Court. And therefore, the proposal from the Attorney-General seems to us to seek further use to a system established to promote reflection, service evaluation and learning for a different purpose. It is therefore, in our view, likely that the amendment will result in the unintended consequence of increasing staff reluctance to engage in this process. In addition, it is our experience that families who are already distressed about the loss of a loved one need a lot of support at this time, both in coming to terms with this loss and understanding the SAI process, why it's being initiated, and their involvement. It is our concern that additional advice to them of the Attorney-General's intervention is likely to compound this distress. And finally, I would draw the committee's attention to the fact that both the Department and the Board has issued, in reference to the Department, I mean the Department of Health and Social Services, and the Board, has issued correspondence to Trust in relation to the legal requirement to report deaths to the coroner under Section 7 of the Coroners Act, and there is explicit reference to this requirement within our documentation. So I would ask the committee to understand that the HSCB welcomes the majority of amendments proposed, but would ask the committee to give further consideration to the proposals suggested by the Attorney-General. Thank you, Chair.
Okay, thank you very much. There's a couple of questions before opening up to other members. The South Eastern Health and Social Care Trust has said they don't have an objection to the proposed amendment, saying that it would provide a clear statutory basis for disclosure of papers and assist the Trust to be clear about what documentation can be released to the Attorney-General. In our package, we have a letter from Mr McGuinness in which you were asking on what authority the Attorney-General was requesting certain papers. So would the amendment be helpful in clarifying that, given that that's exactly what you're asking for in that letter of the 23rd of December?
If I could make an initial response and then ask Mr McGuinness to come in. I have had access to the Trust's responses and to the Departmental of Health response. I think that the South Eastern Trust response comes from a position where they have been asked for papers in the past, and there has been a lack of clarity about what exactly is being requested and how that might be used. I think if you reflect on the whole system, the Health and Social Care Systems response, we are concerned about duplication and the impact on clinicians and families. I think that if this amendment were to proceed, then there is an absolute need for more clarity about what the implications of the amendment might be. But I would ask Alfie to maybe make a response.
I think, Chairman, my letter posed the question, what is the legal authority for access, which is a perfectly legitimate question to ask in the circumstances, because the law is quite clear. In fact, it was a response to that letter, which I don't think you have, which confirmed the Attorney-General's office view that they do not have legal authority to access the documents. But the safeguards, nevertheless, the safeguards are already in place, as Fionnuala has pointed out. The request in that circumstance was in relation to an issue that had been brought to the Attorney's attention by a third party. I don't know the circumstances how it was brought to. But I do know that in that particular case, the Trust had made a determination that there was nothing untoward in respect of the death of the individual. The death had in fact been reported to the coroner. The coroner actually concurred with that view, and as recently as today, and I've seen correspondence just before literally before I came in the door here, one of the more senior medical officers of the Trust met with the coroner's medical advisor, and she agreed completely with the Trust view that there was nothing untoward in respect of that death, and that the coroner would not be changing his original decision, namely not to hold an inquest. And in fact, I think that case actually is a very good example of where this could go, that there would be these nugatory exercises to determine whether there was something untoward when an original decision has already been made by senior Trust staff on the one hand, and then a third party perhaps interfering and saying to the attorney, you should question this further. The role of the coroner is very expressly set out in the Coroners Act. If the coroner makes the decision, and quite rightly that decision is subject to review by the Attorney-General. No one is suggesting otherwise. Those are proper circumstances for the attorney to intervene. But if it's without justification, then it leaves it open to well, abuse is too strong a term perhaps, but unnecessary duplication of effort, unnecessary waste of resources in an already difficult financial circumstance that we have, and will in fact increase the administrative burden on trusts and indeed on medical staff unnecessarily.
We understand that you believe it's unnecessary and could have unintended consequences. I'm going to be mindful of any legislation that we pass of that.
Yeah.
If the proposed power was to be given to the Attorney General, in your view, would it be helpful if we had to make an application to the High Court to exercise such discretion to call for evidence? Because a number of stakeholders have suggested that. Have you any view on that?
Well, it is an option, of course, that is readily available. I do note that my understanding is from other jurisdictions, if you look at in Great Britain, England and Wales and the south of Ireland, the situation is very much as it pertains today in Northern Ireland. They do not have, the attorney does not have additional powers there to access records, reports, information of any description. However, in those jurisdictions, the attorney does retain the power to effectively review a coroner's decision, and we would respectfully suggest that there is no reason to change what is a system that is working apparently extremely well and does have the safeguards not just for those individuals directly affected by the events, but for the public generally, that the attorney can come in if there's a reason that he believes it's necessary to intervene in a coroner's decision. So there is the coroner being the first port of call, in our view, is entirely proper, but it's unnecessary to have another party doing what effectively would be the same, carrying out the same role.
Sean?
Thank you, Chair. Fionnuala, you spoke about the unintended consequences for staff involved in the process. Could you elaborate on that? And just secondly, when the Attorney General was here, he said there was no harm having a second pair of eyes. So do you see him intervening where he shouldn't be?
Okay. Well, I think I've made reference to the unintended consequences to clinical staff and to families. And I suppose, starting with clinical staff, I mean, the people who are dealing with these situations are your frontline nurses and doctors. They are the people who break the bad news, obviously, to the families in the first place. And then they are required to explain about our SAI process, where we feel that the matter needs to be looked at. Our experience is that in itself can lead to all kinds of emotional responses from families. Clearly, they are it's a very distressing time, and they are then, concerned that something may have gone wrong, and we are looking at that to see if there are any lessons that can be learnt from that. So that whole process needs to be managed. Frontline nurses and doctors carry out this function in the knowledge that this is a learning exercise. We're not looking for blame. We're not looking to see who is at fault. We are encouraging an open debate about how we can provide better quality services. So our concern is that the more I suppose, legal powers that you introduce around this whole process, then the more professional clinicians get concerned about the consequences to them as well as their colleagues. I do think our experience is that in relation to family involvement, that it is very distressing at times, and we have to remember that we're talking about the loss of loved ones, sometimes a baby who has died, and it's very challenging for families to understand why we're looking to see if there was anything that could be improved upon. I would also say that there's more than two pairs of eyes looking at this whole process. So just to explain to you, if I might, in the first instance, the procedure requires the trust themselves to carry out their own look back, if you like, on the particular case to understand what interventions happened, who was involved, what measures were taken, and that's when they would be looking at, potentially was there any learning. After that, the information is scrutinised by the Health and Social Care Board, and that process is really quite intensive. It often involves an iteration of looking at reports, asking for more detail, asking for more information, until we are satisfied that everything has been looked at appropriately. And as you've already heard from Alfie, then if it's an unexpected death and all the circumstances under Section 7, it's referred to the coroner who will look at it in his own right as well. So I'm not sure at this stage what the benefit of introducing yet another person in this process, because I do believe that the process as it stands is a robust process. And so I hope that answers your question too.
Thanks.
Yeah, thank you, Chair. With regards to coroner, will the coroner always be assured that he has or she has all the information at hand? And what safeguards is in the system to ensure that that's happening?
Well, the coroner should, there is a legal obligation to provide the coroner with all relevant information pertaining to the death, and that would include reports, that would include records, and the serious adverse incident process or procedures only been introduced in recent years, but that has been added to. I mean, I personally was involved in an inquest last week, and in the consultation, pre-hearing consultation I had with the Trust, I was assured, and I know, that the coroner had been given a copy of the serious adverse incident report, as had the family, and the solicitor on the other side confirmed to me that he had received the serious adverse incident report. The other safeguards are these. Under Section 10 of the Coroners Act, it is an offence not to report a death within the terms of Section 7. In other words, if a death ought to be reported, it's an offence not to report. And so criminal action could be taken against an individual who fails to so report. Further, under Section 17C, offences relating to evidence, it is an offence for any person to do anything that is intended to have the effect of distorting or otherwise altering any evidence. I won't read the whole lot.
No, I understand.
Preventing any evidence or document to be provided. It is also an offence for a person intentionally to suppress or conceal a document, and that person was to be a relevant document, or intentionally to alter or destroy such a document. And a relevant document, just to finish this point, for the purpose of Section 2, a document is a relevant document if it's likely the coroner making any investigation or holding an inquest would wish to be provided with it. And the penalty under that is not just a fine, but potentially up to 6 months in prison. So there is an imperative on not just medical staff within trusts to ensure that, firstly, the death, if it falls within the confines of Section 7, is reported, and secondly, that all relevant documentation is made available to the coroner.
And if Chair, I might add to that, all the documentation that we have within the Health and Social Care family in relation to the serious adverse incident reporting, so we have reporting formats, we have checklists, all make reference to the reporting to the coroner, and that will be something that the designated officer at the board level will be looking at and making sure that it's complied with. So I think there are checks and balances within the process as well to make sure that that happens.
Who qualifies an incident as a serious adverse incident?
Do you want to
Yes, well,
refer to Anne?
within our Health and Social Care Trusts and all arm's length bodies in the department, we would have adverse incidents, and then there is a set of criteria within the SAI procedure which qualifies what would actually determine whether something is a serious adverse incident or not.
And I would take it by the nature of the incident that sometimes could be contested, whether it's a serious adverse incident or not.
Well, I mean, even at times what we would say and what the board would promote with our Health and Social Care Trust is that we'd report as what something that might look like a serious adverse incident may, when a trust then starts to investigate it, they may realise it has not, maybe does not meet the criteria, they will then come back to the board and liaise with whoever the designated review officer is at the board, and a decision will be made whether that can be de-escalated.
I think, Chair, if you looked at the statistical information that we provide to our board, you'll see an increase on SAI
Absolutely.
reporting over the years as this process has been underway. And the reason for that is that we are encouraging reporting, we're encouraging transparency and openness. It's my understanding that our procedure was submitted alongside our response to the consultation, but certainly if that's not available to the committee, we'd be very happy to share it.
Could I make one further point? You alluded, or the committee alluded earlier to the recent case that the Attorney General had written to you about. That was a case that the Trust deemed at senior level was not a serious adverse incident. That remains the Trust position, despite further investigations into that event, and also following the coroner's own independent investigations into that event. It was not a serious adverse incident. So there is a very clear demarcation between what is and what is not, and the criteria are well set out in the document.
When, in your opinion, when is it proper and right that the Attorney General should get involved?
As the law currently states, where he has reason to believe that an inquest should be held, following the decision of the coroner himself or herself. The exact terms are set out in the paper. Well, I think you have the exact terms of Section 14 that have previously been referred to. But it makes it clear that there are particular circumstances where the Attorney General has reason to believe that as this person has died in circumstances which, in his opinion, make the holding of an inquest advisable, he may direct any coroner. Now, can you direct a coroner after the coroner has either made a decision that there should not be an inquest, or indeed he could intervene if the coroner does decide to hold an inquest, but he finds that that inquest was unsatisfactory?
And again, excuse me for my ignorance, but how would the Attorney General know what incidents he should or should be involved in? You know, is there a form of reporting, or is it a case of the public writing, or how would the Attorney General ever get involved in the first instance?
But when the coroner makes the decision, if he's unhappy with the coroner's decision,
Right.
I'm not sure what the interface is between coroner and Attorney General.
Yes.
Whether the coroner reports to the Attorney General on every decision, I don't know what the.
I don't know.
I don't know the circumstances.
Surely
But the present position is if the coroner decides, and I'm aware of situations where the coroner has made decisions not to hold an inquest, and the attorney has intervened, very recently in fact, and has directed an inquest should be held.
Would serious public concern be a trigger for the Attorney General?
After the coroner has made a decision, that could be, or could perhaps even be the family, that they were unhappy with the coroner's decision, or the solicitor for the family said, well, I want to take this further, and presumably there's no impediment to that solicitor making a referral to the Attorney General's office.
And as the law stands at the minute, the Attorney General then would have to go to the High Court?
No, the Attorney General can make the decision.
Right.
That's in Section 14, inquest on the order of the Attorney General. The key point is, though, that it's been to the coroner, it's been through the coroner's books, if you like.
Yeah. And then when he inquires, or the Attorney General makes, asks for information, you are duty bound to give it to him or her?
Well, the attorney will get the information that's been provided to the coroner, and the coroner, there's a duty to provide the raft of information I referred to the coroner in the first place. So unless someone has intentionally withheld documentation, and if they have that as a criminal offence, then the coroner should have all relevant material. There may be additional material, I don't accept that fully, that there could be additional material after the inquest, which maybe forces the hand of the attorney.
But if the coroner gets his lot, how does he know if there's any more? And if the Attorney General only gets the coroner's lot, how can he ensure himself that there's nothing more?
Well, both can request, is there any additional information? The coroners will routinely request statements, for example, from relevant medical and nursing staff, if it's a medical issue, from management, perhaps. They will also get statements
Patient
from
notes.
the patients, or from the family and from the police, and would also have access to the patient records. And the coroner can also institute an independent report if it's a complex medical issue, get a report from that particular specialty. And it's all within the remit of the coroner.
Okay, Chair, leave it at that. Okay.
Can I just take up on that point? So the Attorney General would be entitled to all reports subject to the coroner, but also which you retain, which you don't send to the coroner.
But there wouldn't be there wouldn't be documents that are withheld from the coroner. That's the point of it.
Well, the reason why I asked that question in the John O'Hara inquiry wasn't a report not held illegally, but is now accepted, perhaps would have been enlightening to the coroner if it had been passed on, and that's the Ward report.
Well, actually, in the suggested wording of the amendment from the Attorney General, he states that, I can put my hands on it, but I have it here somewhere. He states that no party should be asked to provide documentation that they would not be asked to provide in a High Court hearing. A person may not be required to produce any document or give any other information under this section if that person could not be compelled to produce that document or give that information in civil proceedings to the High Court. And I think in what you're alluding to in the hyponatremia inquiry, if there's an independent report that's obtained by any party to the inquest, they're not required to disclose that report unless they're intending to rely on it in High Court proceedings.
No, but if say in this particular instance, if the amendment as now tabled had been in place and the second pair of eyes scenario, would the Attorney General have seen the Ward report?
I don't think it would have made any difference because that report...
I'm not saying it would make a difference. I'm just asking would he have seen it?
No.
He wouldn't have seen
In
it?
my view, he would not have seen it.
Right.
Because of that.
So there are documents which are in the possession of the Health Department which may inform the coroner, because from my reading of this now, and I wasn't at the inquiry, so I don't want to pretend that I know of it, but it seems to be accepted that if the Ward report had been at the coroner's court, he may have come to a different decision. And I read on, and it says that, subsequently the department accepted liability in that particular case.
Well, yeah. The Ward report was not provided in the inquest in that case, but the Ward report was not provided in the medical negligence action in that case, because under law there was no requirement to provide the report under the law that exists currently. But even under the law that exists within the Attorney General's proposed amendment, that report would still not, there was no requirement, no legal obligation to furnish that report, because he says a person may not be required to produce any document or information if that person could not be compelled to produce that document in civil proceedings in the High Court. I mean, we're going into a slightly off tangent, but I mean, very briefly, if there's a medical negligence action before the High Court, you're not necessarily required to produce any expert report that you get, which is a report to determine your liability or otherwise, unless you're intending to rely upon it.
No, but I mean, again, I understand the technicalities here, and you maybe need a lawyer to go through them, but when Fionnuala was making her opening remarks, it talked about staff reluctance and not compounding the stress of a deceased person. As a lay person reading this, I ask myself a question in terms of a second pair of eyes. If the Attorney General had seen the Ward report in this particular circumstances, would he have asked, and would he have the power to ask, that should be shown to the coroner?
I don't believe so.
So there can be a report somewhere in the system that would assist the family to find out how their loved one was died, can be held back?
No, it is the nature of the report. I think we're confusing two issues. A report such as that is considering a variety of factors, but one of them is whether or not there was negligence, for example,
Yeah.
right? The ward report in that case was not critical. That is my view. But, so everyone's entitled to a different view. The point of it is, if you're intending to rely on it, then you have to disclose it. That's the legal nicety around it in the High Court. But that is not a relevant factor in this proposed amendment, because the law will be unchanged in respect of that. So it wouldn't make any difference to whether it's a ward report or whether it's a report in respect of an obstetric case, an orthopaedic case, that was obtained for a different purpose.
I think the reassurance we can give the committee is, as I said at the beginning, that the documentation in relation to the patient's care is submitted to the coroner.
No, but I'm just going to read this out because I think it's important for us, for clarity. See, Michael Stitt, QC for the DLS, said the point has been made that this would have been of benefit to the coroner. This may have been the case, but does not mean that the trust acted either illegally or in any way improperly. Now, there's no doubt in that, but it may have been good practice in this instance to provide the coroner with it, because you can be saying something's not illegal or improper, but still allows you room to say, let's do it. Michael Stitt goes on to say the trust notes the evidence from the coroner that he would have expected to have sight of the ward report. So the coroner himself is saying he should have sight of it. Now, I accept that the trust says that with respect, disagree with interpretation of the practice and prevailing legal principles. But that's where the comes in. And that's where, I'm not going to make a judgment on who's right or wrong, because the law may be, but if a second pair of eyes comes in and says, for safety, for good practice, and to prevent or compound the distress of a deceased family, I believe the ward report should have been submitted. Then that gives us the reassurance that where people may not have acted illegally or improperly, then you may go the extra mile and say, let's put all the documents on the table, and there'll be no distress to families in the aftermath in relation to this.
Sure, but this amendment will not achieve that. That's all I'm saying to you.
But if he has access to all documents,
but he wouldn't have access to that if it's not required to be produced in the High Court.
That's perhaps something we should need to look at, because it surprises me. I have to say it surprises me that there can be a document in the possession of a department that subsequently, when it's brought to court, that there are people who feel it would have been a benefit, particularly where the coroner said it would have been a benefit, that even under this legislation, that could happen tomorrow. It's in the gift of yourself, if you don't feel it's illegal or improper to withhold a document that may be, I'm saying may be, of benefit to someone trying to establish the cause of death, then I think maybe that's something we should be looking at in terms of an amendment to the Justice Bill that goes through. Okay, thank you.
Thank you very much, Chair. And I just want to tease out Mr. McGuinness in relation to Section 14.
This will be good.
We're all thinking the same.
I was reading the Hansard from 1959 in relation to this particular debate, and Mr. Topping, whom I think was the Minister for Home Affairs at the time, said this is a power which obviously would be used most sparingly and only in the most exceptional cases. Has there been any change in that, or is that really fixed in terms of the law? Is it a power that, a residual power used by the Attorney General sparingly and in the most exceptional cases?
Well, I'm personally aware of it being used on 2 occasions in recent years. I mean, we're talking, whatever that is, 55 years ago, 56 years ago, when that was stated. But The fact is, whether it's exceptional or not, the power remains open to the Attorney General, and it is a matter for him when he wishes to exercise it. It's not going to be something that will be used, I would have thought, frequently, but it will be used where the coroner believes where the Attorney General believes it's appropriate to intervene, that he's a reason to believe that that an inquest ought to be held. I think the coroner's best placed to answer that when he would wish to use it. I don't see that, whilst it's a debate within the Senate. I think of it in itself is insufficient to say that he could not use it more frequently, but it's where he has reason to believe that that's the key phrase.
And if I could just take that phrase that you've just used, it's his belief that there ought to be an inquest. That threshold is quite low. In comparison to other thresholds that the attorney might have to meet.
Yes, it is. And all the more reason we believe that the amendment is unnecessary because he can still intervene.
Yeah.
The key point is that the coroner makes the first call.
Yeah.
And if unhappy with that call, the attorney can intervene.
So in a sense, the Attorney General's role is to supervise the coroner's system, and if he suspects or believes there's some sort of deficiency in what the coroner's doing, he can then intervene.
I think that was the intention
We
of
believe
the
that was the
legislation.
intention.
Yeah.
It's still available to him.
Yeah. Just one further point, and it relates to the serious adverse incident reports. How would you characterise these reports? Are they documents which are intended really to improve performance, or are they intended as part of an investigation into a death? How would you characterise it?
I mean, our procedures, and I'll bring Anne in a minute, but they are based on best practice internationally.
Yes.
And the purpose of the serious adverse incident system in any jurisdiction and in any business, if you like, even in the aviation industry, is to look to see if things could have been done differently,
yes,
and to take that learning and to change the way you do things to avoid another incident of this nature happening again. So our whole process is based on those principles. That's why I think it's important to understand that, because it's that learning that clinical staff, nurses and doctors want to take from this process, to make sure that they learn from the situation, that they amend their practice. It has led to policy changes, practice guidance changes, as well as individual practice changes. So it's not just the clinician, although it's important that they feel confident that they can go into this without fear that it's about blame. It's not a disciplinary process, that's a separate process. But this particular process, amongst the many that we have, is about learning. But when that learning comes forward, across the Northern Ireland, within the health and social care system, we've looked at, does the policy need to be changed? Do guidance on practice needs to be changed? Does actually our own serious adverse incident procedure need to change? And we've built that in. So, and if I'm not
suggested that there might be a detrimental impact if these are disclosable in the context of this amendment, is that?
I think that what I'm reflecting to the committee is that it's a difficult process for everybody concerned. Doctors, nurses, other clinicians come to care for people, to save life. and to care for people. It's difficult for them. It's equally difficult for the families. Our concern is that we do our best to encourage clinicians to get involved in this process, and just a fear of some reluctance if they feel that it's going to be used, the report's going to be used for a different purpose. So if the report suddenly does get used for blame, for looking at who's at fault, then there is concern about that. Clearly the report is used for a number of purposes at the minute, but the actual investigation is predicated on a basis of looking at learning, not looking at blame and guilt. And I think it is an important distinction, and it's what separates it out from disciplinary procedures and criminal procedures. Those are procedures that can run alongside this, but this is not what this particular process is about.
Thank you very much, Chair.
You think nobody else has indicated? So,
Chair,
Barry,
can I just ask
yeah.
one question? What is the process about them that the Attorney General has proposed? Because it's really difficult if you're saying that all the available information or all the information that's required can be made available under current regulations and law. In your opinion, what is the Attorney General looking for additionally?
I'm not sure that we fully appreciate the need for it. I think that's the
Yeah,
point
that's what I'm trying to
that
establish.
we're making. We feel that there are processes and systems where that information is available, and it can be made available to the Attorney General under certain circumstances. That's already in
Okay.
existence. So we're not quite sure what the intention behind the amendment is, if I'm being honest to the committee. And
So the case you're making is there is no need for it, that everything is in place to make the information available as required. Is that right?
that's what we believe.
Turn that the other way around, and from my perspective,
Yeah.
and what would the difficulty or problems be then introducing this amendment to the bill? If everything is already there, then would this make any difference, and would it be any further inhibitant to yourselves or to the trusts? Or?
I think because of the, it's asking for not just information relating to the death. The coroner is the first port of call. You have to inform the coroner of the death within the terms of Section 7. This opens this, significantly. It could be any document in relation to any death. Lots of people die in hospitals. That is just a natural phenomenon. It's suggesting that the Attorney General will have access to any document relating to any death at any time. It's not even, that's one of the things that I noted about it, it's not limited in time. It says to any well, I'll read it. Can I read the amendment just as he puts it? The Attorney General may, by notice in writing to any person who has provided health care or social care to a deceased person, require that person to produce any document or give any other information which, in the opinion of the Attorney General, may be relevant to the question of whether a direction should be given by the Attorney General under Section 14, which is to order an inquest. Now, where are the limits? There are no limitations within that. There's no boundaries and no limits in terms of time. There's no limits in terms of document. Does it include the medical officers' personnel records, for example? Does it include any other records that may have a peripheral relationship to the death, but are not strictly relevant?
So what you're saying is the current...
So it opens it up to what might be termed a fishing expedition, to effectively undermine the views of senior medical staff who already are in a position and have an obligation, a very serious obligation, to make a decision whether a matter should be referred to the coroner. And if they fail to refer the death to the coroner, as the law exists, when it ought to have been referred, that is a criminal offence.
Just to be clear, though, Chair, with that explanation, the Attorney General's amendment would open up to more information. And it's not well, you're making the case that it's not necessary because all the information is available. It is actually opening up the opportunity to provision of more information.
I think,
But it's not relevant
I think the
information.
dispute or the
Yeah.
discussion needs to be around the relevancy of the information. So I think Alfie's making the point the amendment opens to absolutely anything.
okay.
And I think if you note some of the responses from some of the trusts themselves, it's a point of clarification that they are asking for as well. What actually does this mean in terms of the breadth of information that would be required? There is potential for additional costs. There's potential for additional work in trusts. And as we've already said, because we think the relevant information is available, by and large, there's potential for duplication.
And just finally, sorry for that, Chair, just finally, is there anything else, in your opinion, that could be made available that's not covered under current statute or regulations, that could be somewhere in between what the Attorney-General is looking for, basically, that everything could be available as opposed to what's in the current regulation?
But within the Coroners Act, the coroner is entitled to access any information that's relevant to the person's death. So that is fairly extensive as it sits. The key point is where the situation enters the arena of an inquest. Sorry, not an inquest, because the coroner makes that decision. But when the coroner must intervene, the Act sets out very clearly circumstances, unexplained deaths, where there's an obligation, statutory obligation, to report that death to the coroner and allow the coroner then to undertake investigations. Here, the coroner has available the PSNI to assist investigations. As I understand, I think in England and Wales, there's their own investigators. That's a slightly different thing. But the point of it is, it's the point at which the coroner's role kicks in. And what we're saying is the coroner is the statutory authority to properly investigate unexplained deaths. The duty is on trust staff to report those deaths. What we're saying is there are sufficient safeguards within the current process, and the Attorney General does have a role. We're not denying the Attorney General should have a role. The Attorney General does have a role if he is unhappy with how the coroner has proceeded.
Okay, thanks, Chair.
Raymond had said he wanted a short.
Just for clarity for myself, because when you read out and described it as a fishing expedition, which, I mean, I can understand it.
Sorry, I said it has the potential to be.
Sorry, right.
Okay.
But I mean, you can understand some doctor doesn't want somebody to come to his house and say, I want to read your personal diary, and I can understand that part of it. But to go back to my original question, the second pair of eyes as envisaged by this amendment, the Ward report was commissioned by the Trust. It suggested heavily that the hospital was at fault, yet that wasn't given to the coroner. Under the second pair of eyes scenario, potential as it could be.
I don't think it would make any difference. I honestly don't.
I'm not saying it makes a difference. I'm not saying it makes a difference, but it strikes me that the Ward, my personal opinion is that the Ward report commissioned by the Trust should have been given to the coroner, because it would have assisted in some way to find out the cause of death. It says very, very clearly that the hospital was at fault, and at that stage they hadn't admitted they were at fault. The second pair of eyes would have said, if I was the second pair of eyes reading that particular document, I said, why is that not with the coroner?
I mean, I've explained what happened.
I understand, but the legislation would allow that to happen. At present, it doesn't have to happen. There's nothing to prevent a trust in the future having a similar type of report in their possession and not give it to the coroner. Second pair of eyes gives us the potential that, and he might say, I don't think, or she might say, the Attorney General might say, no, but the potential is there that document would have been with the coroner at the appropriate time.
There is a slight difference, if I can explain, which is the documentation that the Attorney General is talking about are documents that relate to the care and treatment of the patient So it's
And all relevant documents, you could make the case if you're a good lawyer.
Yeah,
it's a
sure,
relevant
sure. No,
document.
but I'll just go back to the point. Any person who's provided health may by notice require in writing to any person who has provided health care or social care to a deceased person, require that person to produce any document or give any other information which in the opinion of the attorney may be relevant, okay? But it's the person who's provided the health care. So it's up to the individuals and indeed the trust to provide the information in relation to the health care.
Yeah.
The distinction that I'm making with the Ward report was that it was a commentary on the care that had previously been provided. You will often get commentaries, expert reports, which will comment on the nature of the treatment that was given, whether it was of a high standard, whether it was good practice, look at the context in which the records were kept, whether it was good record keeping. There are a variety of issues that a commentary could focus on, but it is not necessarily about the actual care and treatment. It's a commentary on the care and treatment.
But it's asked for the people who provided the care. So if it had been in support of someone, you can make the case that this is relevant to the case because the person provided the care asked that the report be commissioned.
The trust asked for it, yes.
That's the people providing the care, or the individual employees can become.
Yeah, but I mean, it's perfectly reasonable for a trust, and indeed the coroner, I've explained that earlier, the coroner can get an expert. I want a report from you, expert, on the orthopaedic treatment, the obstetric treatment, whatever it might be, from that specialist. And a trust will do the same thing. And any, attorney can do that, the family can do that. Yeah. Any party to the inquest is perfectly entitled to obtain an expert report.
So, just in conclusion, I'm sorry for taking so much time, but are you saying if there was a report like the Ward report tomorrow, and the legislation was in place, the trust has the power not to show that to the Attorney General?
Yes, in accordance with even with the attorney's amendment, because the attorney is saying if that person could not be compelled to produce that document or give that information in civil proceedings to the High Court. So if there's a medical negligence action, the plaintiff side and the defence, both parties are perfectly entitled to obtain medical expert reports on the treatment and on the nature of that treatment. If they're going to use that report, they're under an obligation to disclose it. If they're not going to use that report, they're not under an obligation to disclose it.
And the amendment doesn't change that.
The amendment does not change that.
The point that we're making. It doesn't alter the provisions that are extant.
Okay. Okay, thank you very much. Appreciate your time.
Okay.
Thank you very much. Thank you.
No, it's just
Members, may I make a suggestion that mention was made of other jurisdictions and how it operates there. Can I suggest we commission a short research paper just in terms of other jurisdictions? It might be useful in terms of, and just to note that representatives from the Department of Health are up next week on this issue, so we'll be able to throw them on that. Okay. If we move on then to agenda item 5, officials from the Criminal Justice Inspection Northern Ireland will attend, outlining key findings and recommendations from its report on policing and community safety partnerships. If you go to page 44 of your packs, and you'll find the relevant papers there.
44.
Okay, just as they're taking their seats, can I welcome Brendan McGuigan, Chief Inspector of the Criminal Justice Northern Ireland, Inspectors William Priestley and Stephen Dolan to the meeting. The session is being recorded by Hansard and will be on the committee website in due course. So whenever you're ready, if you want to brief us on the key findings, and we'll open up to questions.
Thank you very much indeed, Chair. Could I welcome you to your new role?
Thank you.
And I hope that we can have hopefully a very mutually beneficial relationship, as I certainly did with your predecessor and Vice Chair and members of the committee. We're here to help you in terms of an independent assessment of the subject areas. This report was published in December 2014. PCSPs and district policing and community safety partnerships were established by the Justice Act, Northern Ireland 2011. They replaced the separate district policing partnerships and community safety partnerships, which had been in operation since 2002. Their primary role is to monitor police performance, work with local people to address local concerns in relation to community safety and policing issues, and develop effective responses to help tackle crime, fear of crime and antisocial behaviour. Each PCSP and district PCSP comprises of political members drawn from the local district council, independent members who are appointed by the Northern Ireland Policing Board, and representatives of a number of statutory bodies who are designated as members of the partnership. There are currently 26 PCSPs and 4 district policing community safety partnerships, which have been established in North, South, East and West Belfast. Following the reorganisation of local government, there will be 11 PCSPs, and that will take effect from April 2015. Although PCSPs have delivered successful projects and events at a local level, the absence of reliable performance indicators limited the assessment of their overall impact. The cost of administration and delivery should be rebalanced in favour of the latter. Working relationships with community partners were more successful than those with statutory agencies, and police accountability meetings were most successful when operating in an open and transparent manner. Without a standardised framework to maximise partnership working among statutory, voluntary and community sector providers, it was inevitable that there would be inconsistency of practice across different council areas. Inspectors identified a need for PCSPs to be given guidance on how best to work with partners and how to measure change and improvement. The introduction of community planning offers an opportunity, although a very challenging one, to align the aims of the statutory partners, local authorities and central government with those of the PCSPs. At the end of the current 4-year cycle, the efficiency and viability of PCSPs should be reviewed against baseline performance measures. We made 2 strategic recommendations. The first one is a lengthy one, but it involves that overall relationship between the PCSPs and the local councils. From 2015, the local councils should provide the compliance and assurance framework for PCSPs. The community plan should be the focal point for delivery of the long-term aim of the PCSP. The action plans of the PCSP should feed into the community plan, and alignment should be explicit. The Joint Committee should retain oversight through the Policing Committee reports and regular review of the effectiveness of the PCSPs. The second one actually relates to what really concerned us was the overall administrative costs. So following implementation of the local government reform, the cost of administration should not exceed 20% of the budget allocated to PCSPs. The report also made 9 operational recommendations and identified a number of areas for improvement. As we drill down into those, in terms of governance, the PCSPs are overseen by a joint committee of the Northern Ireland Policing Board and the Community Safety Unit of the Department of Justice. The Joint Committee provides the general direction for the PCSPs and sets strategic objectives for the partnerships. In practice, the government structure of the PCSPs is tripartite, as they are supported and partly funded by the local councils, with council employees playing a major role in managing them. The governance arrangements focus heavily on compliance, but the partnerships would benefit from reduced compliance and more focus on delivery. There is scope for the councils to manage the compliance aspects of PCSPs, with the Joint Committee taking a more strategic role in setting standards for structure, resources and delivery. The costs of administration should be reduced, and a rough benchmark against other public sector services agencies indicates around 20% of cost as an acceptable level. This would still provide over 1.1 million per annum for administration. In terms of monitoring police performance, this is a key aim of the PCSPs, although there was a high degree of variation in the nature and effectiveness of the policing committees. In certain areas, the meetings focused on formal presentation of police recorded crime statistics and exchanges around low-level operational matters. The more successful meetings contributed to the development of policing plans and led to improvements in local policing. Generally, these meetings were less adversarial, the police reports were less corporate, and the performance monitoring was not solely focused on individual transactions. Proposals that PCSPs should receive support through access to crime analysis and guidance on monitoring and challenging police performance should be supported. Alongside the work of PCSPs, there was a range of central government strategies and voluntary and community organisations operating in the same space. Directly attributing a significant success to the PCSPs was difficult and begs the questions, are communities safer due to PCSPs, and would the same result in their absence? The evaluation of individual projects and the work of PCSPs as a whole suffered from a lack of measurable indicators to signpost improvement. There is a need to develop a baseline measure against which projects can be assessed, and the achievements of individual projects need to be evaluated as a programme to achieve sustainable improvements. There were obstacles to successful engagement of statutory agencies in delivering the aims of the partnership. The fusing of local needs with the higher level aims of the statutory agencies needed a clear conduit to a decision-making level within the statutory body. With a community plan to focus outcomes and indicators to measure achievement across a reduced landscape of 11 PCSPs, the chance to strip back bureaucracy, reduce overheads and costs must be taken. The cost of administration and delivery must be rebalanced in favour of the front line. The importance of community safety to underpin these achievements envisaged through community planning highlights the importance of PCSPs in assisting the newly formed local authorities to achieve their long-term aims. We identify a number of challenges going forward. Community planning offers an opportunity, but statutory compulsion might be needed to ensure cooperation. It takes time to develop community plans, and transitional planning should focus on the current action plans with the newly constituted PCSPs, developing action plans to align with the Council's community plan. PCSPs should use their current action plans, updated as necessary until the community planning process is working. Vesting responsibility in councils and council chief executives, a single source of accountability and compliance, will test the will of the Joint Committee, but is essential for improved efficiency. The best management information used by some PCSPs should be rolled out to other areas. Roles of the Partnership Development Officers, PCSP managers and chairs should be reviewed to maximise accountability, delivery and innovation. The role of the Partnership Development Officers could be less compliance and more development, support and performance management. The chairs should be held to account for delivery as much as the PCSP managers. Accountability through improved annual reports, presentations by the chairs to the Joint Committee and feedback from communities should be developed and increased. Efficiency and viability of PCSPs must be assessed in 4 years, and a decision made whether funding at current levels should continue. Should their functions be subsumed into councils? As a question. I think that's all I want to say at this stage.
Thanks for that. Just a couple of questions for opening up again. You made mention the strategic aims, so to improve community safety by tackling crime behaviour and improving community confidence in policing. Talk about the difficulty in assessing that. How did you assess that, and who was responsible for assessing the performance of the PCSPs?
A lot of it was from personal observations. The inspectors spent a great deal of time going round the various PCSPs, sitting in on their meetings, examining the reports from the PCSPs, and indeed talking to both the Department of Justice, the Community Safety Unit, and the Policing Board, to try and get a 360-degree view in terms of the performance of individual PCSPs. PCSPs themselves are quite open in terms of their reporting, and so while some information was available, there wasn't really enough to give you a sense that they kind of were getting under the subject areas to the degree that we would have liked to have seen. Certainly in every area, some areas were performing much better than others, and there was this real inconsistency across the piece.
And in terms of how the public view them, what findings did you have about, first of all, whether the public recognised that they were there and operating, and if they did, what was the public's view of whether they're making any difference or not?
Yeah. Happy to throw this up to my colleagues as well.
I mean, there were surveys carried out, and overall public recognition was low, and it was lower than you would have expected. And in instances where people were aware of PCSPs, it was fair to say that the surveyed results showed that they weren't totally sure what they did.
Oh, when you say it was lower than expected, what were you expecting, and what was the recognition level?
Well, it was very low. In some areas, recognition of PCSPs was 6-7%. And within the granularity of those results, people would not have been able to tell you the name of the chair of the PCSP. In one other survey which looked at communities reporting the PCSPs, it was something like 6 or 7% of people said that they would have gone to their PCSP with community safety issues. So it was low in that respect. I talked to some community groups who were very aware of DPPs, the District Policing Partnerships, and it hadn't really got across that PCSPs had replaced the DPP and the former Community Safety Partnership. Yeah. And one of the, not so much anecdotal because I'd observed it myself, but the branding of PCSPs was a little bit confused in a way, in that the DOJ PSNI aspect of it had equal importance, if you like, in terms of the branding as the PCSP did.
And I mean, you've given certainly the impression there's a real mixed bag there. There's some good stuff going on, there's some not so good stuff. You talked about some of the examples of where a good example is helping to develop a policing plan is less adversarial. Can you give us an actual example of an area where it's been working well and some of the outcomes from the work that they've engaged in?
Yeah, I mean, in terms of policing, and take another example in terms of use of good management information, which led directly to achievement of outcomes. Derry PCSP was notably successful in engaging the police with communities that previously didn't have that level of engagement, and it was achieved in a couple of ways. They used meetings out with the formal PCSP. So rather than a fairly senior police officer, chief inspector, superintendent coming and presenting facts and figures to the policing committee, that did happen. But the operational, transactional stuff has been carried out at local policing partnerships, where you were much more likely to find the local sergeant or that level of officer dealing with community representatives, some of whom may have been independent members of PCSPs, but it wasn't necessarily that formal process. So that was quite successful. Newry was an example where they had accessed a software application that gave them a range of indicators, and that was fed by a number of agencies, sort of agencies that you would expect to be involved in community safety, such as fire and rescue and ambulance and so on, and the housing executive, where antisocial behaviour falls within their bailiwick at times. So that actually was a very positive example. Limavady, where the relationship between the local policing commander and the PCSP was very, very evident. And then there were other areas like Lisburn, where the project in Old Warren Estate and actually Colin community safety projects
what you would say, two projects on different sides of the divide over the years, and there was collaboration there through the PCSP. So you would hold those up as very positive examples.
Okay. Brendan, in your comment, you pondered the question if communities are safer with the existence of them. Would you care to answer that and perhaps give your assessment of how they've operated over the last 4 years and whether you actually believe that there is a case that they should be scrapped altogether?
I must say it was a difficult report in that sense to kind of assess the background information to support the success of the PCSPs was very limited, to be perfectly honest with you. And if we're looking at seriously at the current austerity measures, then any organisation that is costing £25 million over the next 5 years, if this was a government department, I don't think you would accept it. I think you'd be looking for objectives, you'd be looking for targets, and you'd be looking for effective performance management to show that that it's actually delivering. Having said that, I equally know that Northern Ireland and the whole issue around the acceptability of policing is still relatively new, and for the PSNI, it is about forging new relationships, and for some communities, it is about developing that relationship with the police, and in that sense, political representatives and independent members can become an important conduit to assist in that relationship development. So it was kind of one of those reports that really, it's a fine balance. But I think what we came down on the side on was, look, I think you have 4 years here, and I think you should be looking very closely at the performance of the schemes. And then you need to make a very critical evaluation in terms of have they secured the sort of improvements, have they stepped up to the mark in terms of their contribution towards the community planning, and a lot is expected of new councils. They're going to need a lot of help in developing this. This does have access, it does bring together statutory partners, maybe not just as effectively as we would have liked to see them, but then there's no statutory glue there. There's a designation, but actually, what we found was that well, you might have the police commander arrive, and you might only have an official from Department of Health and Social Services, somebody from the Housing Executive. No real clout and no real commitment, and very little opportunity to influence their local service delivery. And so there was a kind of a mismatch there. But we are where we are. The community plan offers a real opportunity to try and provide some cohesion around public service delivery in district council areas. And I think on the basis of that, we certainly felt that there was an opportunity here, but an opportunity that really can't be missed, because it's costly. As it sat, it was spending far too much on administration. And, so there was a real opportunity here to reduce costs and show that they were more effective and had a greater contribution to make in terms of local service delivery.
Paul?
Thank you, Chair. Sympathies for you, because I do feel that you've had to report on something which I regard as nothing but utter waste of public money and an utter waste of my time. I declare an interest, Chair, as being on the old style DPP and then also being a member of the PCSP. I think I've got that right. The point I make is that whilst there is very, very good calibre of personnel within these bodies, and the people who administer it try their best, there's absolutely no reason why what was being administered in the PCSPs couldn't have been delivered within council. You could very well have a policing committee in council or in the new councils, and you could have, with regards to community planning, you could have a committee there, because in my eyes, what was the DPP was much more structured and scrutinised the police more than the PCSPs, because the PCSPs meant that it was divided, their loyalties was divided and their concentration was divided. And it meant that in a lot of occasions, in a lot of places, the police were nearly let off the hook, in the nicest sort of language. And there was no drive there and concentration to actually develop scrutinising of the police and then also really make a difference to plans. And in the best way in the world, the police are far too busy to really have taken the DPPs or the PCSPs with any real degree of seriousness. They come in, they take their hit, and they walk out again and they get on with life. And they'll only worry about the next DPP or PCSP whenever they have to come to collate the figures. And that's basically what I got out of the DPP and the PCSP. There's no reason why you can't have a policing committee within council. And then what was very, very useful was the fact that you administered funding like asset recovery or some sort of community funding safety vehicle. And there was some really good projects out of that. But my point still stands, that could all have been delivered through the committee structure. So you wouldn't have a recruitment cost, you wouldn't have a training cost, and you might say, well, there has to be a place for independent members, and I agree, but they could be invitees into a committee on council. Because there's not one independent member that I met and knew that didn't lose the will to breathe after a number of months and meetings. And that's as damning a verdict you can have on these bodies. And I may be being too extreme, but I believe that I am being realistic in what I say, because in my time, when I walked off a DPP, it was the biggest waste of my time and the biggest waste of public money. How would you respond to that?
Well, I must say, it's not the first time.
He's given up the will to live.
Just keep breathing.
I must say it's not the first time I've heard that, but we are getting into a new era. There is significant challenges in the establishment of the new district council structures. I think they're going to need all the help that they can get in terms of what is envisaged for them. PCSPs, for all of perhaps the ineffectiveness that you observed, still have linkages and connections that it might take councils a considerable time to get up to speed with. But I have no doubt that, after a period of time, if community planning works as effectively as it's envisaged, what you're talking about here could well be the case. And we've already said that actually the overall governance and accountability in terms of the financial dealings of PCSPs could easily fall within the council structure. You don't need to be doing it 2 or 3 different times. Actually, local government accounting processes are more than adequate to deal with this. So there is duplication, triplication of effort on occasions, and there are efficiencies that can be made. But that's why one of the key recommendations around reducing the administrative costs, I think, will help focus minds in terms of what it is that they need to be doing.
Okay, that's it. Raymond?
Thank you very much. I suppose this is for the day tonight. I did declare that there's Ivor Blower and the PCSP in Derry, who seem to do very well out of this, so I'll sit on his laurels this afternoon, right? But in terms, just looking at the administration costs, whose responsibility is it? Paul described some of the independent members losing the will they breathe, but they still remained on it. How do you create the situation where people who aren't functioning or are not allowed to function, how do we intend to? Because the general observation I'll make, is that, in my opinion, and I can only take it from the experience of the constituency, which is Derry, the nature of policing in Derry would have been different without the way the DPP worked and the PCSP works, it would be different policing structures. Now, that's down to possibly the structure, how people go at it, how the local police, respond to it. If a local police commander has the attitude of suck it for an RNC, then it's never going to work. So who's responsible for making sure that nobody goes into a meeting saying suck it and see, and then goes outside and ignores what's costing all this money?
Well, the administration costs were in some ways a legacy of combining the two previous structures, DPP, CSP, because you had two managers that some came together and maybe a project support officer from the CSP who ended up. So the PCSP may have ended up with a number of administrative staff that if you were starting from scratch, you may not have done that, was the first point. The second point was that the point was made by that there was more guidance, more structure around DPP delivery and so on. And in fairness, the Joint Committee, when they were setting up PCSPs, thought perhaps we'll draw back a bit and leave it to get a bit more variety or a bit more local traction in terms of the development. And I think they would say, looking back on that, perhaps they should have delivered more guidance, put more structure around it. So that would have led to issues about non-attendance of independence, the explaining the role perhaps of the designated. Drawn a parallel with another project, Neighbourhood Renewal, which was an attempt at a wide level to bring in statutory bodies and so on, delivering at local levels. Similar issues arose there. It is hard for members who are independents attending a structured meeting where you've got experienced councillors who are used to that format, and they arrive into this trying to influence. You've got statutory bodies who are coming to a meeting. Now, you take the Housing Executive or Educational Library Board, they have a corporate plan, business plan developed over years. They've got very strong governance structures in terms of their delivery. And in my view, do you expect a meeting around a table some Tuesday evening to change how they will deliver that corporate policy? Because they've had a bit of a chat amongst the councillors and independence isn't going to work. So I thought that was a flawed aspect of what they expected. It goes back to Brendan's point about statutory glue, statutory compulsion that they must deliver, which community planning moves a little bit towards, although central government doesn't have a statutory role. The other aspect of administration costs is you had 26 PCSPs. With 11 PCSPs, you would expect the administrative cost to fall in percentage terms. And the other point in admin costs is there are other monies come into PCSPs directly from council and so on. And if you add up all of their funding, that actually would reduce, in a way, the percentage of admin. I didn't have access to that information right at the time that I did the report. But over time, I think you will see that the cost will automatically fall below the level that we quoted. I don't know if it'll get to 20%, but it definitely will fall very quickly. So that might go some way towards assuaging that concern.
And just in terms, I'm just going down this. In terms of Lauren, 100%, all their money spent in admin. No, should someone step down there earlier and say what he's doing?
Well, it's a special case, unfortunately. I'm sure the department officials will be able to fill you in on all of that. There were issues in Lauren where, to be honest, it meant that they weren't receiving any other funding, and the projects were under scrutiny and so on. So there was an issue up there. So that was a problem.
And in terms of, I mean, I asked this in ignorance, the community warden scheme, was that limited to the places that got the money? I can't understand why our places wouldn't use what's obviously a very good scheme on the ground.
It was an application process, wasn't it, for funding from the Department of Community Safety Wardens. I think it was then reviewed, so certain funding was reduced, and I'm not sure actually if Community Safety Wardens funding is now available going forward.
Okay, thank you.
Patsy.
Yeah, thanks very much, Chair. And my apologies, it wasn't in 30 minutes. I was pulled out on other business there. But one of the things, I was the first chair of Cookstown DPP. And one of the things that I notice is, if you were to go out in the street now and ask, what's the PCSP, around where I'm coming from, most people would draw a blank. They have no profile publicly whatsoever in the local papers. I analyse the local papers every week, as anyone should do that has an interest in their local community. No profile, zilch whatsoever. That's the first thing. So connectivity with the local community is zero unless mail shots and the likes that they're putting out about there. But thank you for raising the other issue, because this is one that has been taxing my mind. The DPPs did get the hits occasionally. They had the public meetings, the outreach meetings and that, and they did get the occasional bits and pieces in the local newspapers. Not a lot, but the occasional stuff, and people were aware of that. Not everybody either. So it seems to have gone downhill in terms of public awareness, and therefore if it's gone downhill in terms of public awareness, its effectiveness likewise will be going downhill. And it runs the risk of getting sucked into exactly what it shouldn't be, a purely administrative body where people shuffle paper around the place and that's it. Now, that brings me on to, and thanks for raising it, that was the issue around community planning. Because one of the things all of us hate doing is having to go to a couple of meetings and exactly the same things being done with usually the same people. The only thing that changes is the venue. Sometimes the venue doesn't even change. So with the advent of the community planning, a lot of those issues and a lot of the discourse that would be going on at a PCSP will inevitably, by its very nature, crop up at community planning exercises or meetings too. So I think there's going to have to be a lot of harmonisation. I can understand too why some people would lose the will to breathe at some of these meetings. In Raymond's case there, he referred to it. I think a lot of it has to do with the individual senior police officers for the area too, and other officials. If they have a drive to make this work, rather than coming in, taking it on the chin and walking out the door, that works. And I've seen police officers, senior police officers, who were committed to making it work, who, if anything happened in the locality, were immediately onto the chair of their DPP or whatever it might be, and were deeply committed to the process of public accountability. So that's something from a management point of view, in the instance of the police and other bodies, that has to be looked at. Now, to come back to your point about the issues around the likes of, say, the housing executive come along with their corporate drive and the like, the consultation again has already taken place with the locally elected public body, the council, as do road service. They come in and present their plans to the local council, and the local councillors sit there, and they've all been there, and make your contributions to it. That's their consultation exercise done there. So you're hardly going to come back in and do it all over again at a corporate level. Where it does kick in is the adaptation of, or the response adaptation of, the housing executive and other bodies to what issues that might be in the area, such as the antisocial behaviours that comes up repeatedly, time and time again, or drugs issues, how they respond to them, or it could be alligating. Those types of, if you like, run-of-the-mill but very important issues, and how a public body responds to those within a given area, depending on what they hear around the room or the meeting. So those are a few observations from my point of view, but one of the ones that was very telling there was that in the analysis of the Belfast PCSP, who do you normally contact for policing and community safety concerns? PCSP, 5.3% of respondents said. And obviously more than that. Do you understand the role and functions of the PCSP? 53.9% said no. And that's after all the selling of it and all the glossy brochures that have never been put out into the community. It just isn't being seen, obviously, as a major factor in the communities that it's supposed to be seen in.
Just picking up your point there about the interaction at what you would call tactical or operational level of statutory bodies. Some good examples of that were, as you were alluding to, is that after the corporate plan's been set, I went to a meeting in Carrickfergus where there was a discussion about drop-in centres to do with drug abuse and so on. And it was quite well attended, and by that, in the context of PCSP, there were 50 or 60 people there.
Yes.
And what it did do, it brought officials from the board along, the health board, who certainly would have been involved at that high-level planning. But it was interesting for them to experience, I think, the feedback at a lower level. Because I don't know how much of a difference it's made, and that's one of our issues about measuring that impact. But it gave the opportunity for those people, if you like, to be quizzed by the public or to face public concerns. Rolling it all up into a council committee may actually lose the focus of it amongst all the rest of the council business. So that's something that has to be weighed up about whether PCSP is a separate entity at value.
Well, would you take the point again, just like the police and how they, senior officers, approach the accountability or other ways of the body that they're dealing with and how they respond and adapt and come back to the communities about that? Because one of the things with police has been incredibly bad in some areas, just the most basic of PR, getting back to people.
Yeah.
And that applies to other statutory agencies as well. I'm sure there's not an elected representative in this room that hasn't encountered the really, really good, effective, efficient. May well be only to pick up the phone and say, we're working on that, we'll get back to you. But likewise with those PCSPs and bodies too, their response in getting back and the effectiveness or other ways can a lot depend, almost entirely in some instances, depend on the senior official, be it housing executive or health trust or whatever, and the effectiveness of the response they come back with.
Yeah.
Usually whenever there is no response, or a mediocre or an awful response, then it's back to the elected representatives and there's a special meeting of a council or a committee of the assembly called to where they're held to account. And
well, there were direct observations and quotations to me and the bill that where the police responded quickly, the whole PCSP was seen in a more positive light. It comes down to what is the priority within the organisation in terms of the relationship with PCSP. So that the actual inconsistency that we found was very much personality driven. So you'll have a housing manager executive in one PCSP area being lauded for their input and so on and so forth, and in another area they're invisible. But then that's up to the statutory body to have some form of priority in terms of engagement with the PCSP. And then it's up to the PCSP to say, this is how we measure our performance, and that wasn't happening.
Can we just add, one of the issues impacting on this was that relationship, and that's very much vested in personalities. But it's also vested in how the PCSP went about their business, and where PCSPs have moved beyond the dynamic of holding to account, but we're actually monitoring performance. It seemed to work better. And you may say there's not much difference in that. Well, there isn't. But from the police point of view, if they felt they were being monitored for their performance rather than held to account, I think that relationship was much stronger. It was more of an adult-to-adult transactional relationship.
could you just define to me how in practice that operates now? Held to account and monitored.
It's all to do with the
Because
dynamic.
you're dealing with the same person, and if that person that's been held to account or being monitored has been ineffective, you go the next rung or two up and you bring the senior officer down. You know?
It worked better where it was a monitoring performance, and it was a discussion, an adult-to-adult discussion, rather than berating someone for poor performance, and then the person walking out saying, took that hit, and now I'm out of this meeting. So where the meeting actually was focused on performance and then sustained performance into the future, bringing someone back to describe their performance after the meeting, that dynamic worked better within those successful PCSPs. So rather than berate someone for the performance and they walk out the door and think, that's fine, this is over, there was a dynamic where they came back.
One, and thank you for that, but anyway, one of the things is, again, you're back to management and administrative issues internal to the PCSP. The major issue is, be it good performance, bad performance, the stats coming up well and you're bringing people back in again. Outward to the community, that's not been communicated. And there isn't a connectivity with the community. And mind you, for 25 million, you'd be expecting a whole lot.
Yeah, well, I mean, the channels of communication are there that just need to be exploited. And we touch on that in the areas for improvement in the report, you know, about extending their influence and being clearer about what to do. Bill's touching there on a topic that we discussed, which we sort of described, not in the report, but internally as transactional accountability, so that you had the inspector from the police turning up with a plethora of stats and that flick through them. You know, and it was KSIs or this and drug seizures, and you know, one that I attended where he said drug seizures are down, we didn't meet our target there, but that could be a good thing because it might either mean there's less drugs or maybe we're not catching them as quick as we should. So running through those stats give a bit of comfort to the police perhaps, but it's not monitoring performance. It may be some form of accountability. When you went to some of the other areas where the police committee was looking at community safety being delivered in conjunction with the police, you got a better feel. So instead of all the stats, that we're able to talk anecdotally about activities that were taking place. And some of those then were explained away by the police, and it's not actually a criminal offence to stand at the corner of the street. So there was just a better dynamic, and so it's hard to explain, but it isn't just punching out the numbers, delivering the report, and then walking out the door saying, right, we got away with that for another 3 months, which we did observe.
I think there's something very important I need to say here, because there were some of the PCSP managers who were exceptional.
Yeah.
And if it weren't for their efforts and interventions, I think the overall PCSPs would have floundered. There are some people out there who get this and who understand it, who are labouring under the way the DPPs had functioned in the past, the way that the community safety partnerships had focused in the past. I think there's an opportunity there, and I keep going back to it, that we're expecting a lot from our local councils. There is an opportunity for them to step up to the mark here. These PCSP managers, I think, could become extremely influential in terms of helping chief executives of councils consider how elements of the community plan can be developed. Because they've been doing some of this work, but there just hasn't been the energy to activate some of it. As I say, I think you have to be fair to some of those individuals who have ground on over the years and tried to do the best that they can. And they certainly are out there. And it's those people that I would be hoping that the council chief executives, the new council chief executives, will be making a beeline for, in terms of how it is that they can start to activate some of their knowledge and experience to support the community planning in the new council areas.
Okay. Hope enough.
Thanks, Chair.
Thanks, Chair. And as somebody that has been there before myself from the old DPP, so I've seen some of the difficulties and the teething problems and what you've talked about, Stephen, the stats, and it nearly killed the meeting, and people didn't want to go back to it, and I agree to some extent to Paul, but I did see the reasons for them, and they played a good role in that initial stage of building confidence with communities that hadn't had any engagement with policing. But you have said that the community plan will be central to success, Brendan, and that when operating in an open, transparent manner, that's where. Could you give an example of that?
Well, I think this was in terms of observation during the meeting, that everything was out in the open, that there were free discussions around the police performance, as opposed to just presenting a PowerPoint slide presentation or a raft of statistical data that actually is very difficult to interrogate and to analyse. So when people were up front, and there's nothing better for public service deliverers to actually say, we're not doing enough in this area, and we need to do better than this. And that's a kind of an openness and transparency. Or indeed, if there was a significant issue, that they acknowledge it as a significant issue, and are not blind to the fact that the performance of their organisation could have been better. That's the kind of openness and transparency that I think public representatives welcome, as opposed to people who close up and hunch down and draw themselves in and are less than open in terms of responding to concerns that public representatives and indeed independent members might have about police performance.
The other difficulty was that the community police officers that were in areas were continually changing, and that was one big difficulty that I found when I was on it.
There is no doubt, this whole issue around the relationship with the police, it is vital that citizens have the confidence that they can develop a relationship with individual police officers. That's what it comes down to. The whole issue about talking to the area commander or the new district commanders, It's something quite separate. It's, you know, if you're talking about building police legitimacy, you know, one of the most important elements of that is the fact that the citizen has the ability to engage directly with police officers, or indeed that public representatives can speak to the local sergeant or the local inspector about issues. You know, it doesn't need always to be drawn up into this kind of situation where this has to be talked about at the PCSP meeting.
That's true.
That's not what, you know, that's turning local into parochial, you know, and that's not effective for police leadership either. You know, you have to give them their place, and the fact that individual officers have their responsibility. So, you know, you don't want to undermine that whole relationship between individual police officers and the citizen.
It makes it so much difficult when I know in my own local area, the amount of turnover of police officers, that when you get to know one or a community gets to know one, then they're moved on somewhere else.
Yeah, the individual officers one aspect, but two bits of good practice or comparatives of good and bad practice, if you like. PCSP meeting being held almost like this, with the microphones, the whole show in the big council chamber, being very, very formal, and I found it, attended one of those meetings, sat myself, and found it very difficult to get a discourse going there because it had to be presented, and that led to a very formal relationship, and also projects at the project level where you're engaging with the police, and you have examples where you know, the engagement process was bringing a local policeman to the local grammar school to talk to the children. Okay, but much more successful was actually engaging a couple of the community police officers in a project with kids who actually had convictions and things like that. You know, much harder to reach communities, and that had a much greater impact. So there is an element of conducting the business in a manner which goes beyond some of the boundaries that maybe we're used to in committee and so on.
Can I just ask this one question in relation to, if the same question was asked, you know, who would you normally contact on policing and community safety? As you say, if you're asking that in Donegal or somewhere in England, you know, 29% asking their local councillor seems to me relatively high, and I think that's one of the successes of this. You know, why would somebody see, you know, the local councillor? You know, like, I know when people phone our office, you know, if it's a matter with the PSNI, there are people who specialise in it, and that's usually our people who are on the former DPPs or the CSPs. So sometimes, you know, your statistics can be masked, you know. Absolutely. I mean, I can imagine going to somebody in Donegal and saying, if you have an issue about policing, they'd say, phone the guards. They would never say, contact me, local councillor. So because of the relationship, and I think that's...
The worrying figure in there is that 9% said would contact others without defining who others were.
Yeah,
but,
yeah. But it was even like some, you know, I say it's flippantly, you know, it's like people saying, you know, only 3% who knew their local members were, but I would say they all know where they live, because when they need them, they seem to be able to find them. They might know their names, they might know the exact title, but they certainly can find you when they need you.
Well, that's true.
All right, that's it.
Maybe not as a PCSP member,
But they know you'll take them to a local station.
Thank you very much, Chair. Just in relation to Belfast, you're suggesting there shouldn't be district partnerships, and that probably is, I think, the best approach. Clearly, they're not working in that district sense.
There was an issue there about the role of the principal partnership and the district partnerships.
Yes.
So, from a common sense point of view, a governance point of view, you said, well, the principal ones up there set strategic direction, develops themes, and then the districts deliver and interpret those themes for a local area. It wasn't happening. The districts were totally independent, taking different approaches. There wasn't a great deal of shared practice, and there were issues in the principle, because people there, I talked to a lot of them who said on it and said, we're not actually sure what we do here. And on the districts, for instance, South District saying to me, we've got responsibility for Belfast city centre, but nobody's actually told us why. That seemed to have evolved. West Belfast had a very different approach to East Belfast, and North Belfast then had a different approach again. And some of those worked, but the issue was, how do you share practice when they're actually legally constituted as totally independent bodies, which struck me as not being the way to go. And the other issue was the scale of funding, and certainly when you compared Belfast as it was to, say, somewhere like Magherafelt, Limavady, But with the new 11, the disparity isn't so great in terms of, area and population and even on the money, so.
Have you any estimate what we will save in relation to reducing to 11?
Well, what you're looking at there is, an average of administrative costs of somewhere in the region about 43%.
So if you went down to 20.
If you went down to 20%, then that's a sizable amount of money you're talking about. And what we're saying is, look, if the Assembly decide that that's the way that they are, through the Department of Justice, that's the way that they want to fund this, that's fine, but you would want to ensure that the majority of that funding was actually being directed to the front line, that it wasn't being soaked up in administrative costs. As Stephen had pointed out to me, 20% is quite generous. In some voluntary organisations, you'd be talking about down to about 12%.
Yeah.
So
that's good.
So it's really important.
Yeah, I mean, I concur really with the analysis. But I don't reach the conclusion that we should get rid of PCSPs. I think they do. Potential is there. I don't think they've reached their potential. I think we have to look at them afresh, revamp them. I think some of the ideas that Paul has talked about, PCSPs are attached to councils, but they're not of the council. Maybe greater integration, greater partnership with the council might be a better approach. I just say that by way of comment. I don't expect you to comment on my own comment, but just one thing that I found absent from the report was police's voice. I didn't think the police's voice was coming through this, but maybe I'm wrong. Maybe this is simply an objective outsider's look, and wasn't necessarily intended to reflect the views of the police themselves.
We did absolutely speak to them, and once again, their experience was extremely mixed.
Right.
They would have questioned the value of the PCSPs. Having said that, it was their structure, their formation was part of the police reform programme.
Of course, yeah.
It was about developing acceptability and in many ways mirroring what had happened in other jurisdictions in terms of the Crime and Disorder Act in the mid-90s in England and Wales. But once again, there was a statutory framework around it, and it was generally taken on board by the local councils, but then local councils in England and Wales had experience of managing a whole range of services, education, social care, planning, and indeed a relationship with the police service, which was once again quite mature, and less confrontational. So in many ways, it was built into the Patten report as a mechanism for engaging both local representatives and the citizens in a joint enterprise. And it floundered a bit, and I think it had gone stale under the old DPPs and community safety partnerships. People weren't turning out to support them. There wasn't the energy around it. The police didn't feel that they had the mechanism to move things forward. And in many ways, there was an inertia around some of this. And with the launch of the PCSPs, my concern was that they adopted some of the bad habits of the former structures. And that was the time when actually they needed new direction. Yeah. And so, like you, when I read the report and spoke to a lot of people about it, you just it was in the balance. But equally, in looking ahead, what we could see were the challenges of community planning, and the fact that we know that to deliver effectively on the community planning issue, the local councils are going to need as much support as they can get to actually deliver on this.
Just one final point, Chair, and that is this. The fact, if I were a police commander or senior police management in an area, I think that even though the PCSPs don't seem to be working, at least it provides a framework and it provides a discipline to the local community, that you have to report to the local community what you're doing. I think that discipline informs the way police should work. And I think that's an important aspect of the whole thing that we should never overlook.
Absolutely. Yeah.
It's a good point. The unwritten bit in the report is to say, where have you come from?
Yeah.
You know, so PCSPs, we look at them now in isolation, and you mentioned about the police voice. The very fact that the police are there, that, as you said, and there is an accountability mechanism that needs developed, but that's an improvement on what was there before. And you know, that interaction between communities and the police wasn't there for many years. So
Yeah.
from that point of view, you can say that the concept is right. We need to look at the structure and the administration of it.
Yeah. Thank you very much, Chair.
Summary?
Thank you, Chair, and thank you for your presentation. In your report, you talk about the special arrangements for Belfast, and I want to concentrate on that. And you talk about the interviews you had with the members of the respective bodies. You're quite scathing, and I read here, there's no evidence of accountability, monitoring or performance assessment. So it's quite clear that you had major difficulties with Belfast. So could I ask you that in terms of your recommendation, there should be one PCSP for each local council area, including Belfast, and which means no need for DPCSPs. How did you arrive at that conclusion? Obviously you did an analysis, but did that include your discussions with those respective members, that they also felt there was no need?
Well, that was certainly reflected back to us, and a number of the independent members in particular just felt that it wasn't working. And you know, what we preferred to think of was that you know, there are issues that are Belfast-wide. It's not subject to one particular area. So if it's issues around race hate, if it's issues around domestic violence or sexual violence, or indeed antisocial behaviour, those are issues that cross over any subdivisions of Belfast City. And so, you know, and when you look at it now in the context of the 11 district council structure, Belfast is no bigger than some of the newly amalgamated council areas. It's no bigger. So it's the same population. It's now one police district. It's not 4. It had been 2, and now it's down to 1. It's a single police district. And it just makes more sense that actually the most effective subdivisions of the existing PCSPs were when they picked a theme. So if there was a subgroup of the PCSP that wanted to focus in on sexual violence or domestic violence, actually that was found to be really powerful, a really powerful tool. It was bringing in the experience from different parts of the city or different parts of the district council area around a themed issue, focusing in terms of what the district policing partnership could do to improve the situation. And we found that that approach was much more successful as opposed to what, you know, one area might do different from another. It's not a competition. This is actually about ensuring that there is a consistency of policing delivery right across Northern Ireland.
So, Brendan, you feel strongly that this operational recommendation is 100% as far as you're concerned. You haven't had any second thoughts on it?
None at all.
Clear.
None at all.
Okay, thank you.
None at all.
Thank you, Chair.
Just, Chair, on the point, one point to be made is where you've amalgamated council areas, for instance, it was expressed to us, especially up the northwest, where you're stretching from
Ballycastle right across the side of Limavady, and people in the rural area there saying they felt that we'll lose out because now you've brought in the urban area of Coleraine, and their first thoughts were, well, we'll have a subcommittee called the Limavady part of the new PCSP, and we were counselling against that and saying, well, you'll end up so isolated because the level of representation you'll have and that will be so small. Much better to focus on the themes. And then you can actually evolve. So you can actually maybe have an SVDV themed project But then you can roll forward then and go into wanting drugs, antisocial behaviour. Whereas if you set up the little geographically based groups, they just become marred in their own local and parochial issues, and they don't benefit then. And we saw that with a drug scheme that was put forward by Belfast, one of the district policing partnerships, and they ended up being picked up by Antrim and Newton Abbey and so on. But that was sort of an evolutionary osmotic process rather than some sort of strategic driver. So we are worried about little subgroups forming all over the place, because you will definitely lose the best practice aspect, and that's behind our Belfast thinking as well.
Thank you. Thank you, Chair.
Okay, thank you. That's everyone. Thank you very much for your time. Appreciate it.
Coffee. That's it.
Okay, members, move on to agenda item 6 then. If you go to page 102, 113 of your packs. Members, can I just get you to note that following the briefing, consideration will be given to the Minister's proposals for PCSPs to achieve representativeness from April 2015. So there's an opportunity in this session to ask questions about that as well. So if we just welcome up to the table. Okay, can I welcome Moira Doherty, Deputy Director of Community Safety Unit in the Department, Stephen McCourt and Mary Patterson from the Partnership Development Branch of the Department, Amanda Stewart from the Policing Board. Just to let you know that it's being hand-sorted and will be published on the website in due course. So whenever you're ready, you can respond and ask, open up the questions after that.
Mr Chairman, thank you. I welcome the opportunity to brief the committee on the Department's initial thoughts in response to the CJI inspection report into governance, delivery and outcomes in respect to PCSPs. Just to begin, if I could introduce myself and my colleagues, I'm Moira Doherty, Head of the Community Safety Unit in the DOJ. I'm joined today by Mary Patterson to my far left, who comes from our Partnership Development Branch, Stephen McCourt, who's Head of that branch, and my colleague from the Policing Board, Amanda Stewart, who is the Partnership Director from the Board. The Department and the Board are very grateful to the Inspectorate for agreeing to bring forward their planned inspection of PCSPs in the context of planning for local government reform. And I'm just going to focus my opening remarks on the main issues impacting on PCSPs as a result of the report. In other words, value for money, effectiveness and wider local government reform. Before touching on these issues, I would just like to recap on the role that PCSPs were set up to perform. In other words, engaging with their local community and statutory groups to identify local concerns in relation to community safety and to put in place plans and actions to contribute to a reduction in crime and the enhancement of community safety for that local area. So in other words, local solutions for local problems. They were also there to work in partnership with the police, local statutory bodies and the community to reduce the impact of antisocial behaviour and crime in the community and to improve community confidence in policing. The inspectors have told us that they recognise that amalgamating the previous DPPs and CSPs into a new structure presented challenges. And despite the challenges, as the Chief Inspector said, they did find evidence of some successful projects which PCSPs had delivered, which had made a real difference to their communities. The financial challenges now faced by the whole public sector make it even more important for us to maximise the effectiveness and efficiency of PCSPs, and the Inspectorate's report should help us to achieve that objective. The introduction of community planning and the reduction in the overall number of PCSPs through local government reform provides an opportunity to reduce the cost of administration in favour of frontline delivery and ensure that PCSPs are effective and efficient. However, we do feel that further work will be required to establish whether the figure of 20% as recommended by CJI is appropriate for PCSPs, particularly given the fact that many of the PCSP staff are engaged in frontline operational delivery within communities. We will also need to consider the impact of any thematic subcommittees, and I'll touch on that later. The Department accepts CJI's view that evaluation of projects requires more emphasis on measurable indicators to assess whether or not those interventions have had a positive impact. and we will therefore work with colleagues in the Policing Board and colleagues in DOE to develop appropriate performance measures aligned to those to be developed for district councils for the broader community planning piece. We agree that there's an opportunity to streamline the governance arrangements provided by the Joint Committee, and we accept that the Committee should take a more strategic role in setting standards combined with a more proportionate governance framework. Discussions will commence shortly with relevant stakeholders, particularly Council Chief Executives, regarding implementation of this recommendation. We anticipate that these discussions will consider setting a small number of strategic regional priorities, for example alcohol and drugs or domestic violence, with an opportunity to consider the appropriateness of ring-fencing a portion of the resources to deliver these regional priorities. This should improve the connectivity between priorities at the regional, local and neighbourhood level. Decisions on how these priorities should be best addressed within each PCSP area and what additional local priorities a PCSP may also wish to address will be for each PCSP itself to determine. In terms of the effectiveness of the Policing Committee and holding the PSNI to account, the Independent Commission on Policing envisaged a very active role for local policing structures, and the Commission saw local policing bodies as playing a vital role in promoting policing with the community. The Code of Practice issued by the Department and Policing Board in November 2012 provides guidance rather than prescriptive operational requirements relating to the work of the Policing Committee. And the Policing Board considered the need for more specific guidelines or minimum requirements set out in the Code to ensure regional consistency. In particular, clearer guidance on the reporting requirements for monitoring police performance, a standard pro forma for reporting to the Policing Committee, and greater clarity on the local policing plan process, specifically in relation to the input PCSPs have. The Policing Board has therefore accepted the proposals in the report that PCSPs should receive support through access to more detailed crime analysis data and guidance on monitoring and challenging police performance, and will work with PSNI to implement this proposal. In terms of the relationship between statutory designated bodies and PCSPs, the Department recognises that the reduction in the number of PCSPs through local government reform, plus the arrangements for Belfast, provides a greater opportunity for collaborative partnerships to be developed between PCSPs and the designated bodies. A specific induction programme will be developed for newly appointed members, including designated bodies for each PCSP, to clarify the role of PCSPs and emphasise the important contribution to be made in terms of the broader community planning agenda. CJI has noted the impact that local government reform will have, and the resulting impact on local representation is the main issue for PCSPs. In particular, the report highlights the perceived risk that smaller communities may suffer from a lower level of representation and that constituents may feel a loss of influence when subsumed into a larger district. I understand that this was discussed with PCSP members during the fieldwork stage of the review, and inspectors concluded that dealing with priority issues rather than geography is more likely to ensure an equitable approach on the basis of need. On that basis, they were persuaded towards thematic subgroups rather than geographical subcommittees. The Minister recognises that CJI's recommendations on representativeness provide an important template for the direction of PCSPs from April 2015. And the Minister wishes to explore further with key stakeholders the recommendation on the establishment of thematic committees and subcommittees to address topical or seasonal issues. One aspect to consider is whether such groups are established on a task and finish basis, whereby a group is established for a specific purpose and then disbanded when the objective is achieved. In relation to the Policing Committee of PCSPs, however, the report highlights the significance attached to local accountability and concludes that PCSPs should utilise existing community engagement groups to identify community safety issues and engage with local policing teams to improve delivery. On the Belfast model, as you've heard, the Chief Inspector and fellow inspectors expressed a very strong view on the effectiveness of the principal PCSP and found no evidence of accountability, monitoring or performance assessment of the work being carried out by the district partnerships. Dissolving the current structures in Belfast would, however, require legislative change, and we would of course wish to consult on any change of this nature. Our focus at this stage is to ensure that frontline delivery is maintained until such times as the new PCSPs are established. We envisage that this process will be completed in June, following the appointment of independent members. In the meantime, PCSPs are reviewing and evaluating their current action plans to identify those projects which should be carried forward to 15-16. These will be amalgamated on a cluster basis in line with the new council structure into a delivery plan for the incoming partnerships. There will also be sufficient scope for the new PCSP to develop its own proposals and add to the plan. The Minister recognises the opportunity that the report provides to ensure that PCSPs continue to develop their effectiveness, particularly in the context of the changed strategic environment. Reflecting his determination to ensure a genuine partnership approach to the development of PCSPs, the Minister plans to hold a workshop with Shadow District Council Chief Executives, the Chief Constable, the Chair of the Policing Board and heads of the respective designated bodies in early February to obtain their views on the practicality of the opportunities and challenges presented by these recommendations. The Minister will also be seeking views on the most appropriate method to engage with wider stakeholders, including political representatives, to ensure that all these views are taken into account. Naturally, the views of the Justice Committee are a very important aspect in this approach. In conclusion, Mr Chairman, officials are working in partnership with colleagues in the Policing Board to consider the report in detail and are developing a joint response and plan of action to implement the recommendations. And this will be shared with the committee in due course.
Okay, thank you very much. I just want to ask one question about the cost before opening up with our members, because I suspect many people want to ask questions on this. You've accepted that there are savings to be made because of the reduction down to 11 councils, but somewhat more lukewarm on whether or not you can reach the 20% admin levels that's being recommended. Given that that generally bodies will spend about 10 to 12%, as the report says, on admin costs, how could you justify any of the PCSB spending more than 20% of resources on admin?
Sure. Well, one of the things that I think we're absolutely on the same page with the Inspectorate in terms of the focus on frontline delivery, where we just need to look at the figures that are here carefully, because some of our PCSP managers, where they might be described as admin in terms of the inspection report, when you look at what they're actually doing in their job, some of them are delivering frontline operational, and depending on how it's captured, that could be it could give a slightly different picture than if you had the description of what the people are doing day to day. So that's something that we just wanted to pause. Rather than saying blanket that it's 20%, we want to make sure that we capture that aspect of the PCSP staff's work that is on frontline operational delivery. But we absolutely accept that that's where the focus has to be, and we have to seek to drive down the admin costs as much as possible.
Okay. Sammy?
Thank you, Chair. Thank you for your presentation so far. Well, in relation to this report, and you heard the Inspector there, the question I was going to ask, why are you not accepting the conclusions or the proposals for Belfast?
Well, it's not necessarily that we're not accepting them. I think we just need to look into them in more detail, particularly given that it would require legislation. And certainly, and Amanda can add to this, it's not my understanding that Belfast, when taken in terms of the other districts, has in and around the same population. It's my understanding that Belfast still comes out, I think it's 18% of the overall population for Northern Ireland, and the next nearest is Armagh. Also, Belfast is 31% of the crime across the whole of Northern Ireland. So that was just something that we would need to consider with a much broader stakeholder group, given that it would require legislative change, and just given those particularities around the Belfast area. And is there anything you want to add on that?
If I could just come in to say that at the time the Policing Board was going out to advertise for independent members, it needed to come to a view in terms of the arrangements for Belfast. At that stage we were aware that CJI were potentially looking at it. We had asked them to look at Belfast. We also knew that district policing structures were being reviewed. In that context, and it was within that the board decided, having taken and undertaken a review of Belfast itself the year before, the sense from the members that we spoke to in Belfast was that the district structure was actually particularly effective, and where there was a requirement for change was actually the principle, because it was a potential duplication. And actually the way the legislation is written for Belfast, it does specify that Belfast shouldn't undertake the functions of the district unless it is satisfied that the district isn't performing. And the fact that Belfast Principal didn't undertake any of those functions would suggest that the districts were doing the job that they were set up to do. The board, in comment to its decision, had decided that on the basis that there was the population actually for Belfast is 335,000, and the nearest comparator was Armagh Banbridge in Belfast, or Armagh Banbridge in Craigavon, which was 203. So there still is a significant proportion of the population within Belfast, and obviously the 31% of crime in 13-14 was the key driver for that decision to retain the structure for 4 districts, and that was supported by the police at that time as well.
So I understand that, and about the percentage of crime scale of Belfast, that as well, which to be honest, I thought it myself, I think Belfast will have a max of 50-odd thousand residents, apart from anything else. But if Belfast continues with their present arrangements, my question is this: how does the Department and the Policeman Board propose to address those findings? Because some of the stuff is very scathing, as you've read yourself.
In terms of the report, some of the things that have been said. Well,
and some of the criticisms, the structures, the procedures, not are very scathing, some of that stuff. And how do you propose to address that if this continues in its present form?
In terms of the Policing Board, one of the issues that we have looked at is that in appointing independent members, we would try and ensure that there was duplication between the principal, and so there wasn't any independent members sitting on the principal that weren't part of the subgroups. Because there is an issue for Belfast Principal in terms of disseminating good practice, the whole issue around the city centre. There are a number of specific areas, particularly relevant to Belfast, that the police have raised with us. And there is potential actually for the principal PCSP to take on a much more strategic role, particularly in relation to the visitors coming into Belfast, for instance, and some of those bigger issues, and even around the business community. We are proposing to talk to some of the members on Belfast to get their experience, and obviously in developing the guidance going forward in terms of the code of practice, we would want to reflect some of the comments that were made by CJI. They were just broadly saying that it was in line. My reading of the report was that they were saying that it was in line with the other amalgamation of the councils, which suggested that their rationale was that it was population-based, and that that was the rationale for doing away with the 4 districts. There is definitely an opportunity to assess what the principal PCSP do, and we would be obviously doing that through the development of the guidance and the code of practice. But from the board's perspective, the issue around making sure that there is joined up membership, the legislation provides for the 4 chairs to sit on the Belfast PCSP. We would be proposing that the vice chairs also sit on the Belfast PCSP, and that there is no member on the principal that doesn't actually sit in any of the other districts.
Thanks, Amanda.
okay. From our perspective, and working in collaboration with board colleagues, we're taking the whole of the report and thinking about it. It gives us a very, very helpful steer for this transitional period moving into the new structures. And certainly we need to reflect on what we might need to do in terms of our assessment of training needs, the training guidance for new members, but also looking at ourselves in terms of the governance that we have, the relationship with local chief executives and so on, and the changes that we might need to make there, because it's quite clear that we've a good bit to go in order to improve the effectiveness, and that's in terms of our own contribution as much as the operation of the PCSPs themselves.
So just my final question is that, and you've highlighted it yourself, that this report found there's no evidence of accountability, monitoring or performance assessment work being carried out. So can you reassure us that that will be addressed then? Because if there's a problem there at the moment, it has to be addressed.
Absolutely, and that's why we asked for this inspection to be brought forward, because we think it is really important for us to get off on the right foot. We have an opportunity here. I think particularly with community planning, it does offer a really good opportunity just to reboot the PCSP arrangements and to do more to help them fulfil their potential. I think particularly from when PCSPs, I mean, they've been running now for 2 years, but we're all very conscious of the changed financial context. The money is becoming increasingly precious in terms of public spend, and we have to do all that we can to make sure that it's being spent in the best possible way. So in terms of the governance, we need to make sure that there's a proportionate governance system there that gives assurance around the value for money and performance, but without perhaps what we've seen from this inspection report, the bureaucracy rather than the assurance, and we need to rebalance that.
Yeah. Thanks, Maura. Thank you, Chair.
You talk about potential again, a lot of distance to go, and we heard about the potential in the last evidence session as well, about they're not functioning particularly well in many areas, potential to do good work. Is there going to be another comprehensive review in a number of years to determine whether or not they have become more effective and whether they are more valuable than perhaps some would argue they are now?
Well, if you just remind me, the inspectors will come back
Yeah.
in, when will they do their update?
certainly, we will be bringing the action plan in relation to the Justice Committee in terms of agreeing the action plan in terms of how we're going to take it forward. But as the inspectors have said to your previous evidence in relation to that, Chair, they envisage that there will be a full-blown inspection again and review in relation to the next 4 years in terms of the new PCSPs coming in that regard. So that's what we would be working towards in terms of putting in place the structures now to ensure that when we come to in 4 years' time that there will be, in terms of that continuity, there will be a proper assessment in relation to the work of PCSPs moving forward.
Even in the meantime, it'll be for the joint committee to make sure that we are setting the appropriate performance indicators and monitoring those in an appropriate way. The CJI will then provide us that external validation, I guess, but that's something that we very clearly need to recalibrate is how that performance management is done.
Raymond?
Thank you very much, Alistair. I mean, obviously, as if you like, the people who are the architects of the PCSPs, you have a sense of what should make up an ideal PCSP. I'm just wondering, in light of this report, have you aligned this up with the current structures and looked at it and said, right, here's the theory, now the practice is in A, B, C and D, and give yourself some appraisal of each of the partnerships? Have you taken out that exercise?
That's the process that we're going through at the minute. Obviously, the report was published in December, and we have intensive work to do for the next PCSPs being established. The theory versus the practice, we've had a lot to learn here. I think one of the things that struck us was that the way that the Joint Committee approached some of this was because of the focus on local. We weren't prescriptive about some of the things. So say, for example, admin staffing structures, because the focus for PCSPs had always been around developing that sort of local flexibility. And what we've learned from this report is that actually there should have been perhaps a framework or a target around the amount spent on admin and so on. So there's a bit for us now to go through in engaging with the broader chief executives and so on to try and get that connectivity, just bearing in mind that the pressure of local government reform, that there's a huge change process going on, and we want to make sure that we're involved in that from the outset and that we're going with the grain of that. So that is the exercise that we're going through at the minute.
So the individual meetings with each of the...
Well, what the Minister's planning to have a sort of a workshop to kick it off.
Yeah, no, I understand that, but I mean, what you don't want, or I know if I was sitting on if you have an appraisal of a PCSP and you think it's doing relatively well as per your plan, you don't want to be brought into a meeting where you just say, okay, here's what we all should be doing, and somebody looking back and say, why do that? It's nearly, to me, it should be an exercise of if there's ones that are strong and ones that are weak, you need to go in and start saying, look, you're doing that well, you could be doing this better, you're doing that bad, so you should be doing it. And here's the example. So we don't end up with this sort of generic, coverall, let's do it again, but in 4 years' time, we don't seem to.
I think that sharing of good practice is really important, and that's one of the things that came out very much in the inspector's report. And I think that's something where, in this reboot, I guess, of the relationships, that's something where, in particular, the department and the board need to be taking a more active role in standard setting and encouraging the sharing of best practice. Because there are undoubtedly, I mean, some of the issues I think are around how evidence is captured or how evaluations are done, because it might be, and I really genuinely believe this, that there are lots of very strong, very effective, very innovative projects happening out in communities across Northern Ireland, but they haven't been run in a way that allows the evaluation to demonstrate the difference that's been made. So part of it is about growing that capacity model around better use of evidence evaluation, and it's not just the PCSPs that need to, we're all of us who are engaged in policy making need to be moving more into the space of being able to demonstrate value.
But it's also taking the practical steps. I mean, if you go back to the beginning of the DPTs, say, And that's why I'm not saying that there's any untoward, but no representative of the PSNI to hear some of the because I think they have a big role in the dynamic of making these things work. At the beginning of the DPPs, in theory, all questions had to be submitted in advance. A lot of people would have said that made the meeting very staid. Like everybody knew the question you asked, you had your answer, blah blah blah. Local commanders or local officers then started nearly thinking on their feet and say, well, that does make the meeting. So they started to answer questions spontaneous, and then people said there was better engagement. So as we take that forward, then the police will have a big role in making these more effective, as will our agencies and our parts of it. But I think, the local input from the local structures within the PSNI can make the difference in some of these projects. So I don't know how you relay that. I mean, I know the Chief Constable is going to the workshop. I'm just saying in terms of hearing the district by district analysis, for the Chief Constable, they'd be saying the local people, like, use your feeling here. If you allow your meeting to become a staid microphone meeting, it should be dynamic. It should be engaging, obviously within certain parameters, but certainly to encourage that openness, and that should be right across all the safety aspects.
If I could just add in relation to that, in terms of moving forward, and in terms of the training needs analysis, and in terms of local government reform and the reduction from 26 down to 11, there are huge opportunities in terms of scale to make sure that both in terms of police, both in terms of political members, both in terms of independent members, and importantly designated members and ourselves, that we have an opportunity now to get this right in terms of training needs, to kick off in terms of the reconstitution of the PCSPs, that we move forward in the right way, and in terms of community planning, because the capturing of information in relation to the community plan, which PCSPs can form an integral part, as CJI has already acknowledged, there is an opportunity here to put the process back on track, notwithstanding the fact that there are many good examples in relation to work of PCSPs at the moment. Okay.
If I could just come in on the policing aspects of it, the policing board has recognised that it has perhaps stepped back to allow for that local dynamic to evolve with the new PCSPs in a way that it maybe wasn't being as prescriptive as what it was around DPPs. The opportunity, and obviously the discussions that the board are having with the Chief Constable around the move to 11 districts, which will have co-terminosity with the new PCSPs, is an opportunity to look at that again, where you have one district commander in charge of that particular council area aligned to that PCSP, and in some way or other that had been lost in the move, because obviously PSNI had moved much sooner to 7 or 8 districts, and you still were operating a structure of 26 PCSPs. The Policing Board is also conscious that in reviewing the policing plan, and there's currently a refresh of the policing community strategy ongoing, that it has to align what PCSPs do to support policing in that context, in terms of priorities for policing should also be the priorities for PCSP action plans. They should also be the accountability framework for some of those arrangements, and also for the delivery of policing with the community. And in some way or other, all of that strategic bit had got a bit convoluted, where you have a number of very good projects and all very worthwhile, but in a sense the policing plan should be saying the priorities for PCSPs in terms of policing need to be violent crime, domestic violence and antisocial behaviour, and we maybe weren't being that prescriptive, but there is a recognition that there is maybe a need to go back to that. And also we're working along with PSNI in terms of the new district commanders are just getting into post at the minute, trying to bring them up to speed in terms of understanding what the board's vision for PCSPs will be, and what the requirements are, particularly around even the development of the local policing plan, because in some ways or other CGI were saying to us that get lost in the PCSP structure, where the policing plan was being developed in isolation from the PCSP plan, and actually from input from the PCSPs themselves. So it is a really good opportunity. There's a reconstitution of PCSPs. There's a move to 11 structures. There's a new district structure coming in, which is coterminous with them, and there is an opportunity really to get this right, and to set performance indicators for both the police and the PCSPs that can be measured in terms of the effectiveness of the arrangements going forward.
Okay, and in terms of the representativeness, what work is taken forward now? Is there a piece of work coming forward?
In terms of the geographical point? Yeah, this is something that the Minister also wants to explore, because I think the inspector's view is that we should be looking at thematic subgroups on regional or seasonal issues. rather than drilling down into local areas. So that's something that we'll need to consider, because the Minister in particular, he has a particular emphasis on the representatives in this point and not wanting to dilute that. So that's something that we will have to be exploring. So any views on that would be very welcome.
And what's your timeline for that? Is there a particular timeline, or is
Well,
it just...
we haven't got the overall timeline around this because of the workshop in February. We'll then kick off a number of the actions, but certainly we can let you know once we have the timeline on that, get back to you.
And you'll be back here in terms of discussion, if that's okay. Thank you.
Great. Paul?
Thank you, Chair. Can you give me some examples of things that the PCSP, the new PCSP, will be able to do that couldn't be delivered more efficiently and effectively in a council setting?
The efficiency and effectiveness point, I take where you're coming from, that there does need to be better integration with the overall council. Where we come back to with PCSPs is the bit around our overall legislative framework around the policing with the community, the accountability, and the fact that that's enshrined in the way that it is in the legislation. In terms of the efficiency and effectiveness, I would agree that integration with the council and the other council functions, particularly now that we're moving into community planning, I would say that there are definitely opportunities there.
And I don't want to put words in your mouth, but basically what we're saying is that it's because it's in legislation we have to do it.
Well, I wouldn't say that it's just because, I mean, obviously the fact that it's in legislation, it's the law, and that's for a reason, it's very important, but I think also the fact that it reflects the unique emphasis on that civic engagement and that local accountability for policing that was envisaged by Patton.
Well, you talk about civic engagement. Nobody hardly knows PCSPs or a member of a PCSP, but yet council gets blamed for everything. So why are we doing something over again that has clearly failed?
You mean in terms of reconstituting PCSPs?
Yes.
Well, I wouldn't necessarily accept that PCSPs have failed. I think definitely there's a way to go in terms of improving their performance and improving how they're overseen and governed. But I wouldn't necessarily accept that they've failed, given that, I suppose from our perspective, when you see the range of projects that have been delivered that have made a real difference, you know, I would defend them from that perspective.
And I wouldn't deny that for one moment, because I know of some of the good work that has come through or been channeled through the PCSPs, but they could have been delivered and ran through a council system just as effectively and probably more efficiently. Yeah, certainly. Yeah.
Sorry, Chair. Just to emphasise the fact that in many respects they are not part of the council structure, but they are drawn in many regards in relation to a council framework in terms of the makeup of the PCSPs, because of the majority of the councillors on the committee in that regard, and indeed in relation to the staffing structure which is provided by council staff, and indeed in terms of CJI, in terms of some of the evidence that they brought forward in terms of the good practice, for instance in Newry and Mourne, in terms of the hub and the analysis hub that they had to capture information across the council. It wasn't just PCSP related. So in many respects a lot of them are drawn into the council framework. What we're saying is we could make it better moving forward, and I think the point that you're making is that you know, there is an improvement to be made in relation to that, and the CJI is acknowledged in that respect.
One of the criticisms actually that we have heard of PCSPs is that they have become very much like a council committee, and that in a sense has stagnated the opportunity for them to be out in communities and engaging in the way that they were envisaged to be set up. And some people are put off by actually the structure because they operate like a committee of council. It's quite off-putting, and a number of young people in particular that we spoke to don't engage with PCSPs because they're not familiar with a committee structure within council. And even some of the independent members have said to us in terms of whenever we conduct exit interviews, that in a sense is what has put them off, that it's that formality of the structure, and that would probably be one of the reasons. And obviously from the Policing Board we would say that model of independent members in terms of the Policing Board and then at PCSPs is an effective model, and you would expect me to say that. One of the difficulties that we've struggled with, even with DPPs, was actually trying to assess their effectiveness without getting into numbers and seats and crime figures. And in a sense, I was just struck by something that somebody said to me: how do you measure success when success was that nothing happened? And in a lot of communities, that's what they're doing. They're ensuring that something doesn't happen, and it's very difficult to capture that. And it is a piece of work that we need to do, but it is a difficult piece of work that we've struggled with over the last number of years.
Your strategic objective 2, to improve community safety by tackling crime and antisocial behaviour through, and there are 2 bullet points, ensuring the local statutory bodies and agencies deal with the antisocial behaviour and crime-related issues that matter in their area, and then working in partnership with the police, local statutory bodies, agencies and the community to reduce the impact of antisocial behaviour and crime on the community. Now, I take for granted that second bullet point is very, very worthwhile and really good work and needs to be done, but at the same time easy said. But how? Tell me how a PCSP can tackle crime.
Well, in a sense, the aspiration around this, and the model that the Policing Board envisaged was quite simple. The police come along and say, here are the issues that we have in this community around crime and community safety. What the board had envisaged happening with the PCSPs, to some extent, is happening, and on others, CGI would say is not, and we would probably admit it's not as well. That the police say, here's what as a police service we will do to tackle those particular issues. But what are you, other partners around the table, going to do? And that's the bit that I think is missing, to be honest with you. I don't think that it's all joined up enough at a local level to actually make a difference.
Yeah,
if you set a particular issue around domestic violence, the police come and say, here's what we're doing, the statutory agencies say what we're doing, and the local community is obviously brought in terms of here's our input to it, and you measure the effectiveness of that. That to me is a good and effective PCSP that's working well, but I'm not sure that that is happening in a lot of cases.
You're absolutely right. You've hit the nail on the head. And I was really leading on to my next question, which is how can you ever ensure that local statutory bodies and agencies will deal with antisocial behaviour? Because PCSP have no regulatory statutory framework in this. The housing executive do, the council do, and the police do. And on more occasions than enough, what those 3 agencies do is hand people log sheets to fill in. And the crime, the antisocial behaviour continues and continues, and more log sheets get filled in. How can you ensure that local statutories will actually effectively deal with it, except for handing out log sheets?
Well, I think that's one of the things that we're definitely going to be looking at in terms of the next stage is around the role of the designated bodies, where what they see their role there when they're around the table. Are they just turning up to a meeting, or are they there to actually engage with the issues and deliver a joined up and collaborative solution? So that is something that in particular we're looking now. Not just the Minister intends to engage with the heads of the designated bodies, but also it's something that we need to think about in terms of the induction and the training, so that anyone who is, first of all, that the right people are around the table, and that those that when they are, that they know clearly what is expected of them when they're there. Because particularly for crime and antisocial behaviour, it's something that we in the Justice Department are saying constantly, that we come at the end of the line, and that particularly for things like antisocial behaviour, it's the other social interventions that are outside of the justice sphere that can have the best impact, particularly on the early intervention and prevention point. So having all those people around the table actively engaged is extremely important.
But what is expected of them? Because I don't believe a PCSP knows what's expected of a statutory body. Because they'll come and they'll sit there, and when they're asked to do some, they'll say, I need to take that back. Don't think we have the varies for that. Certainly don't have the budget. Shrug their shoulders.
I think the issue was touched on by CJI earlier. It was the statutory compulsion. The police are coming along, and the police commander has devolved operational responsibility, is the decision maker within that body in that district. What you have is the statutory bodies who are not compelled by statute other than anything to be there. And there is probably, whenever the Justice Act was being developed, there was a discussion around whether you would mirror the crime and disorder partnerships, where you actually had to have organisations, statutory bodies whose plans had a statute to contribute to community safety. And in some ways, I think there's probably a legislative piece there that needs to go back on. The police have certainly said to the board that they are disappointed that that bit of the Justice Act didn't come through, and there is maybe an opportunity to have a look at it again. But community planning, to some extent, I think will provide that framework as well.
So if community planning provides that framework, why not just have it in community planning?
And that may be one of the issues in terms of what we're looking at now, in terms of the way forward, in terms of that, looking to see, you know, how do councils, how do shadow chief executives, how do councils themselves and political members, how does the Justice Committee, how does the Policing Board, in terms of that, see PCSPs evolving in that regard? Will they provide, for argument's sake, the framework for the safer aspect in relation to a community plan? Because there is a compulsion on community planning partners to actually ensure that their plans, etc., in terms of their own specific plans, mirror that of the community plan in terms of commitments. So there is that natural spine running through, which wasn't there before, and it's an opportunity in relation to see, can we exploit that fact in terms of building and strengthening PCSPs and moving forward.
Okay, Chair, thank you very much. Just I want to say, whilst I would be quite damning on the PCSPs, I do appreciate the work that the individuals do within them and the work that they do on the ground, because they do try their best. It's not they're not at fault. It's the system. Thank you, John.
Thanks, Chair. Following on from the CJI, and two meetings that you mentioned, I think, Maria, was the discussions with the CEOs, the new CEOs. I think they're going to be very, very important in rectifying some of the problems from the outset. And will they be, you know, compulsory for those CEOs to go to? And the other step I believe is important to rectifying some of the problems is the stakeholder meetings. Mm-hmm. So those are two key, I think, pillars in rectifying many of the problems that we have seen outlined here today.
Well, thank you for that. In terms of compelling the shadow chief executives, obviously we wouldn't have the power to compel. However, I don't think that would be necessary. I think that so far we have had really good engagement with shadow chief executives. We've two representatives who've been engaging with us, particularly on some of the transitional points, and I don't think there'll be any lack of appetite there to work with us to ensure that this very, very important function is made as effective as possible. And also it's an opportunity for them to speak directly to the Minister to give their feedback on how they've seen PCSPs operating and how they might see things having to change.
Yeah.
Yeah, thanks very much, Chair, and thank you. A number of things just during the course of your presentation there. First of all, to get back to your point on the demonstrating value, I think really it has to be stripped all the way and demonstrate effectiveness. Now, and in that regard, I was a wee bit concerned to hear what you were saying about the Policing Board stepping back from that, because effectiveness in the instance of the Policing Board, and indeed replicated in a consistent manner right across the other statutory agencies and the officials who attend, is crucial. And if they're not punching at their weight and stepping back to allow things to evolve, you're going to have a patchwork quilt, and you're back here in another 2 or 3 years' time with the same report, only it'll be for 11 rather than 26. And you still haven't your problem solved. So it would concern me a bit that the police are stepping back, removing themselves from it, and that then could be looked upon by other statutory agencies. Well, police are backing off to let them evolve. I think a dynamic was the phrase that you used, all of their own. And that has been the problem, that there hasn't been a consistent pattern of effectiveness. And if you want to determine effectiveness, one method of effectiveness is communication, which is so crucial for a community safety partnership. You have the resources to look at your local papers. Run it across all your local papers for the last, say, 12 months. See how many stories there are which are directly as a consequence of the activity of a community safety partnership. That's one benchmark to look at. And I think you'll be surprised at the dearth of stuff that there is. And that is one method of connectivity with your local communities, which is very important, those outlets of the local papers. There was, you mentioned earlier there, I was listening to yourself talking about training needs. However, and Raymond was touching upon this as well, if you have a situation where you really don't know, if you haven't got a SWOT analysis basically of each of the PCSPs, you really aren't targeting your training needs best. Now those could be, as I mentioned, the issue of the statutory agencies, not some of them in some PCSPs not pulling their weight. It could be down to an ineffective person. It could be a management issue by the manager of the PCSP. But if you're going in with the one-size-fits-all approach to this, you'll still not really tackle the problems and issues that there are where there's good practice and bad practice. And at the end of it all, the concern would be if you don't know what problem you're tackling at each 11 individual locations, we'll call it that, with the new councils, then you're going to wind up with a solution which won't match each of the 11 because you won't have a solution. And you'll still have the repetitive nature of the problems facing you again and coming back. So those are some of the observations just based on what you're saying. And it's back to that key point. How do you ensure that good practice is driven both by the Policing Board, by the Department of Justice, and right across the north and a consistent, effective approach is driven by in partnership and conjunction with the statutory agencies. Like, for example, one of the things I'd be wondering was how often would the chief executives of the key elements of this, such as Policing Board, such as the Chief Constable, such as the chief executives of the relevant trusts, health trusts within a given area, and the regional manager for the housing executive, how often do they actually come together and say, right, this is how we need to drive things on here, these are the issues that are coming up, how can we do things better? I'd be surprised. I would expect that it should happen on a very structured basis, but I'd be surprised if you tell me that it is happening on a structured and properly managed basis.
Well, I think in terms of your point around the sort of sufficiently senior people coming together, I think that's something that would be perfect for us to pick up in the workshop, because we'll have those people round the table. In terms of the training needs, I think that's a point very well met, in that there are some of the responses to the report that are really for the board and the department to recalibrate the governance and how we do our business, and we can do that regardless, because that's something which should apply across the board in terms of improving effectiveness. But I think the point that you make around sort of individual SWOT analyses and being much more responsive to what the issue is in the particular area in terms of the training need, I think that's something that we need to reflect on and capture.
If I could just come in and clarify my point around the effectiveness and drawing back. What I was referring to was that whenever we were doing the consultation on PCSPs, the Policing Board in particular around the DPPs was heavily criticised because it was viewed as being too prescriptive around what DPPs at that time had to do. So in developing the guidance and the code of practice, there was a conscious decision taken at that time not to be as prescriptive in terms of you're required to do this by this stage and this by this stage. And to some extent, CJI have said we have probably moved too far back around some of that, and particularly around the policing aspects of it. And that's where you have a disparity between districts in terms of one commander is going along and presenting in a particular way, and another, whereas the Policing Board would have controlled that. It is hard to get a happy balance. There is a balance to be struck in there, and it's somewhere probably in the middle. But it came from a criticism in the consultation that we were too prescriptive and we were actually stagnating the local development of DPPs.
I wasn't suggesting it wasn't what you do, it's the how you do it bit, because that's the bit that comes back time and again. You can have a very good senior police officer coming along who's on the ball, back to people back to the DPP, make sure things get done. Or you can somebody that comes along, DPP, here's the stats, here you go, I'm away, see you in 3 months' time. So it's the effect, back to that effectiveness issue, that would clearly for me be an issue for the policing board to make sure that good practice is driven, and good practice in terms of the public accountability and how that is done effectively and efficiently, and that should be just consistent right across the whole public sector.
Yeah.
It's how that is done, and that's driven downwards, and that I think would help those PCSPs to do the work. Now, and then just finally, you mentioned the issue of coterminosity, and forgive my ignorance in this, but how are you going to divide 7 into 11?
We're not, actually.
Well, I know that. That's why you said about the coterminosity. And
The police are moving to 11 districts in April 2015,
right.
which will allow coterminosity, and that's what we haven't had before, which in some way or other I think has probably impacted, particularly around the policing structures,
Yes.
where you have a chief inspector responsible for 2 or 3 different areas, or 2 chief inspectors
Yes.
straddling different areas. So there was a decision taken, and the board pushed very heavily to ensure that the police districts
Yes.
that were being established in April were coterminous with the new council boundaries, which would in turn make them coterminous with PCSPs.
all right, that makes sense. At last. So, thank you.
If I could just add in relation to the training needs analysis, just one of the things that we have now that we have never had before is this report to act as the benchmark in relation to setting out what is good practice and what can be improved upon. So that's the benchmark what we're setting from, and then why we asked CJI to bring the report forward, taking on board the fact of local government reform and the fact that the 26 would no longer be in existence as we're moving to potentially new members, etc., in relation to the new 11 structure.
Okay, thank you.
Okay.
Thanks, Chair.
Chair, thanks. Just very briefly, I noticed you indicated there may be a review of the 20% proposal to for administration cost to run the partnerships. Can I ask what it's 20% off? Is it just the core funding? Because obviously PCSPs have the opportunity to bring in other funding as well. But is it just of that core funding, or does it include other funding that's brought in?
It would be 20% of the total funding.
Okay. So if they actually double that by bringing in other monies from other areas, or even increase it by 50%, that may end up as only 10% of their overall budget, then would that be right?
That's right.
Okay. And if you were going to review it, notice you said there you may review it or change that, what would you be thinking of?
Well, I think...
Because, sorry, I noticed some of them are quite well over the 20%.
And I think what we just want to understand really well before we put advice to the Minister and before the Minister would make a decision on it is understanding, or at least understanding the extent to which, in particular, what we didn't want to lose, some of our PCSP managers would spend a significant proportion of their time on frontline delivery. And there was some feeling, particularly we met with PCSP managers when the report was published, there was some feeling among the managers that the work that they did and that their staff did, that they perceived as frontline delivery and really making a difference, that wasn't captured when their salaries were badged as admin. So it's just that we want to have a very clear understanding, first of all, for us to do a little bit more field work and have a better analysis ourselves in terms of what would be appropriate, and we're not saying that 20% isn't, but also then in terms of how we categorise the money that's spent on the salaries of those members of staff, to make sure that what we're providing is something which is an accurate reflection of what they do.
CJI, in relation to the report, acknowledged in terms of the evidence that they brought forward that they were comparing just purely the admin cost of supporting the PCSP, and they didn't reflect the fact of what duties those people were performing. As Maura has rightly said, some are actually, in terms of a significant proportion of their time is in frontline delivery. Now, in accounting terms, that would be moved out of admin into programme management, which would have given a completely different perspective in relation to the figures.
If I could just add, sorry, as well, it's also important to try to find the story behind the figures that are set out in the CJI report in terms of the amounts currently spent on admin and operations, because in some of the partnerships, the council match funding is perhaps used primarily to run projects, and they use the joint committee funding primarily to fund the machine behind that. And so it's very difficult to draw any kind of a direct comparison, is really what I'm saying, because they're all doing perhaps slightly different things in that regard.
Okay.
But the principle remains that the focus has to be on the frontline delivery and a reduction of the admin. But the precise number is something that we need to do more work on.
Okay, thank you.
Thanks. Thank you very much. Appreciate your time.
Thank you.
Okay, members, before we move on to the next agenda, I'm just ask you content to note the CGI report on PCSPs and the response from the department. Is anybody wanting any additional information? Probably have to note at this stage, yeah? Okay, agenda item 7, we'll try to rattle through this as quickly as we can. Can I refer you to pages 115 through to 130 of your packs? Back in June 2014, the committee considered the department's initial proposals to achieve local representativeness, following the reduction of the number of PCSPs from 26 to 11 from April 2015, in line with new council structures arising from reform of local government. The proposals involve the establishment of committees by each PCSP and policing committee, as provided for in the current legislation, to ensure that the capacity to obtain and understand the views of those living within the district rather than increasing the overall membership of the PCSPs. The committee agreed to consider the matter further following an oral briefing on the CGI report on the review of PCSPs. The Minister, while continuing to consider the conclusions and recommendations of that report regarding the issue of representativeness, does not consider it necessary to amend the legislative framework of PCSPs at this stage, and believes the existing provisions provide sufficient flexibility to allow for effective subcommittee structures to ensure the critical thematic issues and local priorities are identified and addressed. The committees can be constituted and dissolved as required to mitigate against any lack of representation in the new PCSPs. The Department's written briefing paper sets out further information on the potential role of the committees and the functions that they may perform. The paper also highlights that the Justice Act 2011 provides further safeguards to ensuring representativeness by ensuring, as far as practicable, that the political appointees reflect the balance of parties on the Council at the time the appointments are made, and that the appointment of independent members is made so as to secure, as far as practicable, the members of the PCSP taken together are representative of the community in the district. Can I ask members, are you content to note the intended approach to achieve local representativeness from the 1st of April 2015 in relation to PCSPs? Yeah. Okay, agenda item 8 then, if I refer you to page 132 of your packs. The Department of Justice is proposing to make 2 statutory rules to make provision for the disclosure of information which is furnished to the Department of Justice or any court in connection with the case of an individual seeking or receiving representation under a criminal aid certificate or civil legal services. Both rules will be subject to the affirmative resolution procedure. The criminal regulations make provision for the disclosure of information which is furnished to the Department or any court in connection with the case of an individual seeking or receiving representation under a criminal aid certificate granted under Part 3 of the Legal Aid, Advice and Assistance in Northern Ireland Order 1981. The civil regulations make provision for the disclosure of information which is furnished to the Department of Justice in connection with an individual seeking or receiving civil legal services. Those regulations also require the provision of information from suppliers to the Director of Legal Aid casework and waive the rules of privilege and confidentiality. The committee considered the proposals back on the 17th of September and was content for the Department to undertake a targeted consultation on them. The Department has now provided the results of that consultation and has advised that 3 substantive responses were received, with the Law Society recommending some drafting points, all of which have been accepted. Can I ask members, are we content with the proposed statutory rules, or whether anyone wishes to seek any additional information? We're content?
Mm-hmm.
Okay.
Yes. Yes.
Move on then to agenda item 9, page 157 of your packs. The Department of Justice is proposing to make a statute rule which will be subject to the negative resolution procedure to make provision for costs to be awarded to parties at the end of a civil case in which legal aid has been a feature. The rule covers the following areas in relation to costs. First, the determination of the retainer of a solicitor providing funded services upon the withdrawal of funding, the giving of security for costs, the assessment of a funded client's resources for the purposes of Article 18.1 of the Order, the procedure for making a cost order against a funded client and against the department, the determination of costs under an order for costs in favour of a funded client, and the receipt and application of property and costs recovered on behalf of a funded client. The committee considered the proposals on the 22nd of October 2014 and was content for the department to undertake a targeted consultation on them. The department has now provided the results of that consultation and has indicated that the Law Society recommended some changes and has set out its response to them. The department has also highlighted that the initial draft regulations also included provision concerning the operation of the statutory charge. However, following consultation, it has decided to bring forward separate regulations dealing with this aspect. Again, can I ask members, are they content with the proposed statutory rule, or does anybody wish to have any additional information? Happy enough, yeah? Yep. Okay, can I move on then to agenda item 10? Refer members to page 183 of their packs. The Minister for Justice announced plans for review on the law of unduly lenient sentencing on the 29th of September 2014 in the context of an Assembly question on sentencing in animal welfare cases. In recent months, there have been also calls for the Department to review the existing law arising from offences around certain types of environmental crime and offences where elderly or vulnerable people have been defrauded of money. The Minister now proposes to take the review forward by way of a public consultation exercise and has provided a copy of the draft consultation document which outlines that the purpose of the review is to consider the current legislation and to assess what improvements, if any, could be made. The consultation document sets out the context of the review, the current law, how it operates, and the law in other jurisdictions and statistics on the use of review powers across jurisdictions, as well as setting out the consultation issues and questions which cover a range of issues, including the types of cases that can be reviewed, the filters in place, the timetable in which cases must be referred. So can I ask members, are you content for the proposed consultation on the review of the law on unduly lenient sentences to take place?
Yeah.
And then we'll consider it further once we have any further information. Is that okay?
Sure.
Yeah. Agenda item 11. Refer to page 224 of your packs. I'd remind members that in September 2014, the committee noted the intention of the department to undertake a targeted consultation on extending a provision in the Domestic Violence, Crime and Victims Act 2004 to enable the joint conviction of members of a household who cause or allow a child or vulnerable adult to suffer serious physical harm, and agreed to consider the matter further when the results of the consultation were available. The offence would relate to circumstances whereby the injuries to the child or vulnerable adult must have been sustained at the hands of one of a limited number of members of the household, but there is insufficient evidence to point to the particular person responsible. The Domestic Violence, Crime and Victims Amendment Act 2012 introduced such an offence in England and Wales. The Department has now provided a summary of the 12 responses received to the consultation and has indicated that overall respondents were supportive of the proposed provision and welcomed it, noting that it would provide additional protections to children and vulnerable adults. It's therefore the Department's intention to extend the scope of the current provision into the Domestic Violence, Crime and Victims Act 2004 to cover the new offence by way of an amendment to the Justice Bill. Can I again ask members, are they content with the Department's proposal to include the provision as an amendment to the Justice Bill?
Yep.
Yep. Yeah. Okay. Move on then to agenda item 12, which is correspondence. There's 5 items of correspondence at pages 258 through to 289 in the meeting folder, and there's 1 item at page 31 of your table papers. I'm just going to mention a couple of the items here. Item 4 at page 276 of the meeting folder is a response from the Department providing an update on the Programme for Government Commitment 54, which is reduced the level of serious crime. The response provides further information regarding the achievement of the targets relating to PFG Commitment 54, but does not provide the detailed information that the committee had requested regarding current levels of serious crime. Can I get members to agree that we write back to the Department to again request the detailed information on the levels of serious crime in Northern Ireland?
Yeah.
Item 1, page 31 of the tabled pack, there's a response from the Department to the committee's request for further information on the extent of unpaid fines and the amount that will not be recovered. The response indicates that 31st of March 2014, the total outstanding debt was 22.684 million, and it's estimated that 7.335 million of this is impaired and unlikely to be collected. I'm quite sure everybody would have noted the media coverage of the issue this morning. The PAC published its report on the Northern Ireland Courts and Tribunal Service Trust Statement 2012-13, earlier today and is highly critical of the way in which financial penalties and fines have been managed, and states that despite the significant levels of outstanding debt, the Department of Justice has failed to coordinate a joined-up approach to fine collection, and as a result, current governance arrangements are unsatisfactory. The Department has 1 month to formally respond in writing to the findings of the PAC report and then consider the response. So once the Public Accounts Committee has completed its scrutiny of this, the committee may want to look at this issue further. Can I also suggest perhaps that we would commission a piece of research on how this issue of enforcement is handled in other jurisdictions and whether there's similar problems? I think it might be useful for us when we come to look at this issue again, so we'll get that done as well. It'll help us in terms of the fines and enforcement bill that will be coming to the committee as well. And when we're on that issue, can I also ask that we get agreement from the committee to write to the department just to request confirmation that the fines and enforcement bill is actually on schedule for introduction to the Assembly? It's originally meant to be in for March, April time, so just to make sure that's still on track. Yeah?
Great.
Okay. Anyone have any issues in the other?
In terms of, sorry, our pack sent out item number 4, the letter from Mr. John White in relation to whether or not SSA investigators are permitted under the sort of PACE codes to carry out investigations. I'm just wondering if we could write to the department here doesn't seem to be wanting the answer. Could we write directly to the DSD minister just to set out?
We worked with the committee. Did we agree to write to the committee last week?
Sorry, I wasn't here. My apologies.
No, I appreciate that. We haven't anything back yet, have we?
Yeah.
We agreed to refer the matter to the Social Development Committee and ask them to look at it.
Copy us in then.
Yeah. No, because it's a very straight contention, and on the face of the legislation there is no mention of SSA, but it could be regulation or something. But it seems to just being going round and round, where it seems to be a very straight. They either have the power, they haven't, and they'll be laid out in statute first. So that's great. Thank you.
That's okay, no problem. Move on to agenda item 13, Chairman's business. Yesterday, a number of us met with the designate UK Anti-Slavery Commissioner, Kevin Hyland, and he outlined some of the work that he's going to be doing and the role in which he'll be engaged in. I don't know if anybody who was there wanted to make any further comment. He did say that he would be keen to touch base with us again once he's formally taken his role up, and to see how he intends to take it forward in Northern Ireland. So unless anybody else was there has anything to say, some of you?
Chairman, I thought it was very helpful because he certainly shared his own experience of a number of countries, including international countries, and just dealing with some of these matters. So I think he's a key guy to keep in touch with and to share information with and to give us a bit of...
If everybody's happy, then next time he's over in Northern Ireland, we'll maybe schedule a committee meeting with him. I think it would be useful just to take that forward. Okay. And then secondly, the Mental Capacity Bill. The results of the consultation on the draft Mental Capacity Bill and the Justice Policy proposals were due to be provided to the committee last month, but have still not been received. Can I get agreement of members to request an update on when the results and analysis of the consultation will be provided to the committee, a timetable for the Mental Capacity Bill, including confirmation that both departments, obviously both Justice and Health, are on course to introduce the bill in the Assembly no later than April of this year? Happy enough to do that? Yeah?
Sorry, a final item of business here, correspondence, Chair, just...
Yes, sir.
Have you other issues?
No, go ahead.
Okay, thanks very much, Chair. That's Paul, you'd probably be interested in this one, the correspondence there from Roberta Tasker. I think she has articulated the case very well, and indeed the savings to police estimated there to be 100,000 as a result of the intervention support of the Ballymena Railway Street Clinic. So would it be appropriate that we forward this to the department to inform their decision-making process in relation to this matter, Chair?
Yeah, we briefly discussed that earlier on.
Actually, sorry, right.
It's okay, no, you haven't arrived yet, but Paul's visiting them tomorrow. I was meant to, but I'm going to have to reschedule that. And we'd written to the department before asking specifically about this project, so we're still waiting for some sort of substantial response from them.
Maybe could I make a proposal that this correspondence be forwarded up to the department, because as somebody who's clearly dealing with people who have all sorts of difficulties, I think it, more than probably any of us could make the case, she makes it very well.
That's fine, and the Minister's up next week, and we can ask specific issues around this as well.
You have mentioned that I'm visiting the service tomorrow at 10 o'clock. Can I just open that up to members of the committee if they have, I know it's short notice, but if you have that spare hour or so, 10 o'clock at Railway Street in Ballymena, you're all very welcome. I'm sure they'll not mind if you can make it.
No, I can't.
Okay, well, as I said, I was meant to go tomorrow. I'm going to reschedule that, so I'll maybe bounce an email out to everybody for when I reschedule. We'll see if it suits anybody else to go, because it might be not a bad thing to do. Move on then to agenda item 14. Any other business? Anybody? Any other issues?
Chair, I have one issue, and again, it's all around the detail of the finances and the budgets and the in-year monitorings and all of this, but something that may well have fell through the cracks in our scrutiny of it, and maybe they haven't delved down right enough to make us aware of it. But I don't know how many members will be aware, but there's about 7 voluntary search and rescue groups in Northern Ireland, ranging from the North West Mountain Rescue Team, and you'll know the story that broke in the news about the 2 walkers who got lost on Boxing Day, and if they hadn't been found that night, they would have died. It was these people here, both male and female, that rescued them. It wasn't the PSNI, it was these. Now, PSNI calls them out, and these people go out in voluntary, in vehicles which they fuel themselves, and the training which they pay for themselves. But there's 7. There's the Foyle Search and Rescue, there's Loughney, there's Lough Erne, and there's 7 in total.
There's one about
Mourne. There's also the Mourne Mountains. Skywatch, which are a group that sends up a drone to enable the other ones to help the search and rescue to find people. And there's one also that searches caves. So there's 7 in total. And the North West Mountain Rescue were funded by Sports NI out of DCAT. And this year, for some reason, whatever, they shifted over and are now under the funding masters of DOJ. Now, DOJ has basically told them, you have £40,000 for all 7 of you. You'll have to compete and draw for that funding. Now, these groups all work in partnership together. If Foyle Search and Rescuers haven't bothered trying to locate someone, they will call up the North West, and they will all help and work in tandem. And just to give you some context, North West Mountain Rescue were getting £22,000 off Sports NI 2 years ago. That was reduced to £18,000 last year, and it wasn't enough. But that's 50% of that budget, that pot that DOJ is setting aside, and that's only for one of the 7. So there's going to be massive issues here. Make no mistake about it, the PSNI could not do this job, because whilst they have people trained in mountain rescue, they are police officers doing other roles. So these people get a phone call and they get out of their beds and they leave their lives and they go and rescue people. Voluntary. And you can never pay for that. And PSNI don't have the capacity to do it.
Are they exclusively reliant on government funding?
They do a lot of work. They do a lot of fundraising. Yeah. But the point is then, if they spend all of their time fundraising,
they don't have time to do what they're in.
They don't have time to train, and they don't have time to rescue people when they're called out. Now, they are very aware of the budget restraints and the austerity measures and everything else, and they understand that. But there is most definitely, and I'm sick and tired of hearing civil service telling us that we have to cut. And there is no innovation out of them whatsoever. There's ways and means that we can support these groups, whether it be even servicing their vehicles. They have 4 vehicles, and they have to service them themselves. If that was put into the PSNI conveyor belt and have them serviced, or if even the PSNI was to fuel their vehicles, and I think the fuel price for a year is £8,000, which they have to spend out of their own pockets, out of their own grips, to fuel these vehicles. If there's ways and means that DOJ can do things to help this group, I believe they should be doing it. Not just saying, here's 40,000, compete for it yourselves, may the best group win, so be it. Because they all help each other. And I would ask that this committee And I'm sure we're bound to be talking to somebody about a January monitoring round soon, or about the budget soon. And if it's in the next couple of weeks, that's fine.
Minister's up next week, so it's...
That's okay.
What we could do is we can write to the department on this issue, say it's been highlighted by yourself, and say that we may wish to touch on this next week when he's up.
That would be perfect. Thank you, Chair.
You've 2 or 3 things that you...
You see, just this process is, I just noticed today from the PCSPs, the proceeds, the assets and the proceeds of crime. Can we get a sort of, maybe next week, just to ask, the application process for that?
Yeah.
Because it strikes me, that's, I don't want to take away from any of the money that our people are getting, but it strikes me as that type of money going down type of groups will have a direct impact. I'm not undermining some of the work that some of the other groups that do, but that's the type of direct correlation that should be
And it's just not mountain, can I add? It's not mountain, if there's a vulnerable adult who goes missing.
Yeah, I see. The foil search and rescue is I mean, you live in Derry, you just sort of know their value. You just know their value.
And the police cannot have the capacity to send 40 people out to look for someone who's suicidal. These people are the people who'd find them.
No.
Yeah, thanks for your point. Well done, Paul.
Okay, agenda item 15, and date, time, place, next meeting, 27th of January, 12:45 in the Senate Chamber. Kathleen Marshall will attend out on the key findings, recommendations, and report on child sexual exploitation. Okay.
12:45.
12:45.
This is the Northern Ireland